How could she do this? How could she do this?
This order was there, my lord. They
How
submitted.
could she change it behind the back of the parties?
That is what I say. Why?
She should understand that she is holding a responsible position. Ask her, is this the usual practice for her to do? No, is this your usual practice? Are you not aware when you give a hearing in your open chamber and you dictate an order, you are not authorized to correct it later on? If you have to correct it, you have to call for these persons, take them into confidence and then correct it.
Paragraph 3, she has said, my lord, inadvertently has said to court.
How can she rectify me? Even if we put it under heading to be mentioned to correct mistakes, sir.
I am obliged to you, lord. I have said, he said that it was not.
Mistakes may occur, but there is a procedure for the same. This cannot be done.
Lord, obviously tenders will unconditional apology for that because that was not her intent.
Where is her apology? Where is her apology in the affidavit?
In our presence, lordship says.
No apology in the affidavit. One thinks one can do whatever they like, feel like.
But it is not benefiting anybody, lord.
No, that is not the issue.
Not the issue.
That is not the issue.
Not the issue. What is falling from my lord's mind, that is absolutely correct. That cannot happen, should not happen anywhere.
After an order is signed by this court, unsigned order, we recall it by to be mentioned.
Absolutely, my lord, absolutely.
But after it is signed, I cannot change it.
That's why, my lord, it comes under heading to be mentioned in our presence. Things are being done. I'm obliged.
And what is her explanation in the order? Why she could not change the venue?
That's yes. Venue, there is
Yes, kindly come to the order.
The order, my lord, may I please the order?
My lord, may I read the observation?
Yes.
It has been observed that the plaintiff's claim is vague and riddled with many contradictions. The venue which has been sought by the plaintiff is located far away from the registered office of the society. My lord, I fail to understand how that is relevant. My lord, registered office, how is it is relevant? My lord,
Where was the election held on the last occasion?
My lord, this is for the first time.
Where was the election held on the
Lord,
last? Ask her not to directly submit, Mr. Nayak. She has to submit through you. Yes. Ask her when was the election? Where was the election held on the last occasion?
On the same place.
My lord, this is the first time election is being held.
Very well. Let her file an affidavit by tomorrow.
First time
in course of the day.
being...
Matter will appear tomorrow.
My lord, what we had, my lord,
No. This will not.
Lordship kindly considers, my lord, already a venue has been fixed. My lord, no change we are making up. No change. We are not making a prayer for change. My lord,
No, then I will take the petitioner to task. Petitioner cannot go by this. If it is on the same venue on the last occasion, that was not disclosed. That was not disclosed to me.
My lord, this is for the first time election is being held.
Very well. Let her produce the records of last election. Since
the venue which has been sought by the plaintiff is located far away from the registered office of the society, whereas the Deulbari Dijapara Oboitonik Primary School is nearest within 500 meters from the registered office of the society with proper infrastructural facilities. The society is running at a net loss of rupees 47,000 something, my lord. On behalf of the defendants, learned advocate has stated that out of 778 members of the said society, only 238 signatures are found in the writ petitions, whereas, my lord, we have submitted 297 signatures. As enclosed in the writ petition by the petitioners filed by the plaintiff petitioners, whereas 115 members had signed both the mass petitions lodged by the plaintiff and defendants to the redressal end. The plaintiff, Sri Shobharanjan Tati, has said that he is not sure about the fact as stated by the learned advocate of the defendants. During the hearing, it has also revealed that on behalf of the members, one of the contesting candidates, Sri Bidyut Mondol, stated that he, along with other members, 115 numbers, have signed both the mass petitions. During the hearing, 7 number of such members were present, whose signatures were taken for consideration. After conclusion of the hearing of the case, I am in accordance with justice, equity, and good conscience, do hereby stated that the venue of the said election shall
Why?
remain unchanged.
Why? What is the reason? Ask her. Ask her. It's an unreasoned order. Absolutely unreasoned order. No reasons have been provided for this.
But she has said,
No, what she has stated. She has stated good conscience. I'm deciding it here. Why?
apart from that, it is stated, my lord, in both the representation, 115 members are common.
So as it is, her conduct is not good. And on top of it, I find that this is her explanation. What is this going on? The court has directed her to consider the representation. She must understand. Direction is issued by the court. She is not to take anyone's dictates. It is the court who is directing her. An appropriate consideration has to be made. Not like this.
My lord,
She will change the order. Or the whims and fancies.
that's it, explain, my lord.
No, explanation is not acceptable. Then in that case, I will very well. Sir, if you say that she has explained, then I'll consider it this fashion.
It pattern, my lord.
And there is no apology from her also.
She is before your lordship.
No. This is unacceptable, Mr. Nayak.
She is extending, my lord. She is
Where is the apology in the affidavit?
writing, but in presence.
Ought to have been in writing. Ought to have been in writing. There is no explanation, nothing. She does not care for the direction issued by the court. This is the manner in which she disposed of an order passed by the court. Where is the reasons?
She is tendering, but in writing.
No. Where is the reasons in the order?
But reason is
Hey, or complete karo. Be that as it may.
reason is
the
That's what I
results.
said also.
I did not want her presence also today, but she would understand what she is doing and the consequences therefore. And when a direction of the High Court has been issued,
Not so
it is no ordinary direction. It's the
found
highest
it-
state in the court,
So
it's the highest court in the state, sir, issues this direction
after
and does
consent-
not comply with the direction. The direction should be complied in the letter and spirit. This has to percolate to the officers. When a direction is issued, you have to adhere to the direction.
Lordship, that is there. At the same time, Lordship, I appreciate, but election is a long process.
Maybe,
And my lord,
maybe,
everything is
but a representation has been made. The court in the fitness of things
according to
exercised the discretion in favor of the
according to her
petitioner
capacity,
and
not
directed her to consider. She can't just throw it away.
that. My lord, she has explained, but according to her
Our explanation and in the and our conduct does not appear to be fair. I am just stopping it here. I am not saying anything further than that.
according to her
Let us see
understanding,
what happens tomorrow.
But if we are informed that the place of the hearing, my lord, we will inform our client to be present at 4 p.m. today.
why-
No, she will do it with you. You speak to her. She'll give you the appropriate.
that she will explain
Yes,
what is
yes,
passing order and she will also deliver it.
Yes, yes, and if necessary, she will issue mobile messages. We shall send necessary.
Today, your lordship has directed a
Four,
hearing
four, four.
at 4 p.m.
Yes, at her office. You go to a chamber at for
My
court has
my
directed.
lord, my lord.
So you go to her office
My lord.
and ask her to also inform the other side.
Other
There
side,
are certain defendants or someone is there.
One, my lord, one
they are the
person.
petitioners.
No,
We both
someone is
got-
there also.
Yes.
Apart from them, one
And
person.
one learned advocate had to appear, my lord.
Yes, inform that person.
My lord, if we
Filing
know about
ask
the
him.
identity of
But
the
that person should have been. She is aware of the situation. He is aware that the matter is pending before the court.
Lordship,
Yes, ask her to inform her.
My lord.
Inform them.
But she cannot know the address also. I also do not know. My learned friend can not help
My lord,
us.
it is only
Help us.
How did she notify him?
Uh,
How did she notify?
through the ARO. Through the ARO, she.
Yes, ask her to inform through the arrow.
Lordship, that-
I'll upload it by 12:30. By 2. By 2. I upload this order by 2. Today at 5. Make it at 5. It will be easier. Yes, yes.
And no further notice in writing.
No.
will be issued.
Yes. Call the original side matter.
grateful, my lord.
Affidavit taken on. Huh?
Grateful, Lord.
কালকে 10:30 Tomorrow at 10:30. Matter is there tomorrow at 10:30.
Grateful, Lord.
Fine. And dispose of the same by passing a reasoned order. এটাকে আপলোড করতে হবে তুমি কালকে এখনই পাঠিয়ে এখানে বসে কারেকশন করে দেবো আমি কারেকশন দরকার আছে তুমি দিয়ে করে দেবো যত তাড়াতাড়ি আপলোড করে দেবেন হ্যাঁ
A very short point. On the last occasion, your lordship passed an order saying that matter will be hard on the point of maintainability. Matter will be hard on the point of maintainability. Your lordship has passed an order. The last occasion. That whether
What are you challenging?
I have challenged an order of adjudication imposing penalty upon me. An order of adjudication imposing penalty upon me.
Adjudication under the provisions of?
Customs Act 1962.
Yes.
Is admittedly an appealable order.
129, you have to prefer an appeal?
128
128, yes.
before the commissioner.
Yes. So why have you come here?
Well, this will be under 129A before the tribunal because it is commissioner, the second step. Now, my lord, I have
7.5% of the duty of the penalty you have to pay.
That's not a problem. If your lordship wants, I can make
No, not that.
10%
Why will I
penalty.
take it up before this court?
Why? My only ground, my single ground is I have been imposed with penalty under section 112 of the customer upon a finding which is extraneous to 112. But I have been charged under, suppose for theft.
Show me.
Yes, that's the only point. Kindly take.
But that point is not jurisdictional issue.
Why I am saying so? Because murder, I have been punished for murder. But the finding against me that I have not murdered. I was in theft. So at best I can be punished for theft. not for murder.
No, question is, sir, this is within his jurisdiction to issue this direction.
Kindly take page 432, volume 2. If after hearing me that, Lord,
432.
432,
432.
432,
Are you sure there is 432?
volume 2.
For him
Volume
to, there is
3,
no.
volume 3. I saw.
Yes.
The last sentence, 432, I impose penalty of rupees 60,000, 60 lakh on the notice number 9, that is the petitioner over here, under section 100.
No, what is that page 435?
435 is the order of tribunal where I have been exonerated from the charge on which he has imposed me penalty. That is the peculiarity of this case. If your lordship allow me 2 minutes time, what is the case? One import consignment came. I was a CHA. Import consignment was filed for warehousing. I worked there. I was authorized, I worked. Consignment was transferred to the warehouse. Complete job is complete. I have issued my NOC, admitted position on to the party importer. Importer took away. After 2 months, importer through another CHA filed an application for warehouse transfer, Kolkata to Kanpur. I am not a party over there. My job was over. I was advocate in lower court. Now a higher court advocate has appeared. Now, while transit from Kolkata warehouse to Kanpur warehouse, the consignment gone missing. I was not a CHA in that consignment transfer. My work ended 2 months back. I issued NOC, all he has recorded.
The penalty has been set aside.
Penalty has been imposed on me.
By order of 440, penalty has been set aside.
Well, there are 2 proceedings parallel. One is for penalty under 112. Under 112 penalty. Another proceeding under customs broker licensing regulation.
Customs Act karo. Yes.
Another proceeding is parallelly under customs broker licensing regulation. If a custom broker fails to charge, if a custom broker
এই
fails
তো তলায় দেখতে পাচ্ছ, তোমরা তো বই দেখো না, তাই জন্য খুঁজেও পাও না কোথায়।
one proceeding is under section 124 of the Custom Act,
This was under customs broker
licensing regulation.
regulation. So that was, the penalty was set aside.
In custom broker licensing regulation, my license was revoked for this, and I was imposed with penalty, and my security deposit was forfeited. 3 penalties, punishments, all have been set aside by the tribunal. Upon the finding that I was not a party,
So you go before the tribunal.
I'm coming to that. I'm coming
Why
to
will you not go before the
that. I
tribunal?
am before your lordship.
Why will you not go before the
I will
tribunal?
go. I will go. If your lordship asks me to go, I will go. I
No,
have
no,
no
Mr.
problem.
Chakraborty, why will this
Why?
court take
Why?
up this matter?
Why?
What is the jurisdictional issue involved?
But one thing only. This adjudication, they have made a mockery. That is why I am before your lordship. Without listening to anything, without looking into anything, recording everything, they will impose me mechanical penalty. And every time I have to go before tribunal. One order from this institution, from this highest institution, will awake them that they cannot act in this manner. This is not a mockery. I was not a CHA. I have been penalized.
Any appeal has been filed from this order?
No. And the most funny thing, my lord, after the tribunal order, even today, they have not restored my license. On the reason that this 60 lakh penalty is upon you, which has got no connection with license. This is what they are doing regularly. Whatever we submit in adjudication, they simply record it and they impose penalty. Kindly see the finding against me. The finding he has given is at page 427. The only finding against me. Okay. And well, a movie show.
Now, there was an illegal removal.
Not at my hand. I was a lawyer in the trial court.
Yes, now come to the adjudication order.
Kindly see the finding at 427 against me. Tribunal found that I was not a CH in that time at that time. My job over. Kindly see paragraph 3.9.2. First minor 3.9.1 last sentence. And then 3.9.2. Only CBLR violation. And CBLR violation has been dealt with by tribunal. And for CBLR violation, 112 is not attracted. That is why it is without jurisdiction.
No, 9.2
Yes.
is not his finding.
Yes. 3.9.2. But I find.
Please read.
I find.
Please read.
Yes. I find.
I find okay, Mr. Chakraborty. Please read. Please place it loudly. I will also read with you. Place it loudly.
Very well.
I find that in their submissions, there means your
I'm coming.
defense case.
Let me read. Let me place. I find that in their submission, he notically submitted that there was no involvement found on their part by the investigating officer for the alleged diversion of the imported goods during bond-to-bond transfer. Also, they denied the allegation made in the show cause notice regarding the working principle. The allegation I made denied. Kindly read this sentence with me, Mellor. Also, they denied the allegation made in the SCN. Now he is writing what is the allegation regarding the working.
So there are two parts up to this, Mr. Chakraborty. Let us.
Correct.
I am trying to accept what you are saying as correct and proceeding to test it out, Mr. Chakraborty. Not that I am trying to find faults.
So your lordship has never done.
No. So I am trying to first of all accept what you say is correct and then testing it out.
Very well.
While you say that this is your finding, I find here, this is my finding here, that he records, I find the defense submission.
Correct.
So this is all that is defense submission.
Very well. Then where is
And
this
then he says, I find these submissions without merit. Next line, these signs without merit. And he quotes that judgment from the Supreme Court and says that the whatever it is, he's whatever, he may be wrong, right, indifferent.
Well,
I'm not going to the issue.
Well, let me read.
Yes, yes.
Let me read.
Yes.
What is his finding then? Then, according to your lordship's reading, his finding starts from the word.
So therefore, therefore, there is no finding as of now that your involvement is not there. As of now, that finding is not there. So therefore you proceed. Proceeding further. That is 3.10.1. You read from there.
It is not for me. My part is over. After that, 3.10 is not about me.
Not for about you.
Not about me.
So 3.9. His finding he has given here.
Bas, that is his finding. No finding.
Maybe it is no finding. Maybe it is no finding. But Mr. Chakraborty, maybe it is no finding. But the question for consideration before this court is whether prima facie it would transpire from the order passed by the tribunal. I find that your case I have found out. It is very clear. Your case may be what you wanted to spell out, that you had been altered and thereafter the actual issue had happened. But that has to be examined.
That has been examined. That has been examined. Now, my lord, may I show your lordship one more thing?
Yes.
One more thing. What was my submission before him? He's an adjudicator. He's to adjudicate. Kindly take. Dharaway. Page 417.
Yes. Yes.
2.8. He has quoted in his words, by bullet point, my submission. Now it starts from Roman 1 to A, B, C, D, E. Next page, F, G, H, I, J, K, L. Next page, M, N. Has he dealt with any of my contention? Your lordship has found his finding against me.
Very well. That is your case?
That is my case.
Yes, Mr. Mude.
So there are two proceedings. One. First is that he acted as a customs broker. There were some irregularities conducted by them. For that, we proceeded under the CPLR regulations. For that, his license was revoked, and ultimately they went to the tribunal, and tribunal passed an order. Now,
If I accept the tribunal's order, then you are out.
yardsticks are different. Yardstick for assessment is different because that is for the irregularities conducted as a customs broker under CPLR. That is for his revocation and suspension of license. Now, over here, this is a show cause notice which is under section 28, read with section 124. That is for the loss of revenue which has occurred to the department and imposition of penalty. Now, tastes are totally different and the yardsticks are different. Now, over here, the show cause, as per the
Show cause is under?
My lord.
Show cause is under?
Under section 28 as well as section 124, that is for recovery of the duty foregone as well as for imposition of penalty.
Which page is the show cause?
Yes, the show cause is at page
23A.
23A.
Volume 1.
Now, if your lordship kindly sees the show cause, the penultimate portion of the show cause, wherein we have clearly laid down as to what we are asking and what for they have been show caused. পেজটা কত যেখানে প্রপোজ যেটা শেষ হচ্ছে যেখানে যেটা বললো
Page,
Yes,
page,
now
page.
now lordship kindly comes to page 97,
No, starts at page.
starts at page 23A. Lordship kindly sees page 23A.
And the foundation of the 97 is? Foundation for 97.
97 lordship kindly comes to page 97, paragraph J, before 75.
Yeah, I've seen that. That is his
where
final why he has been penalized.
this
But
is
why? Basis.
Yes.
Page 94.
lordship kindly comes to page 94.
Yes, roll off.
Paragraph
That-
73. In this show cause notice, we have indicated what role the petitioner has played for which the show cause has been issued.
Yes.
Now, show cause was accepted. There was no challenge thrown to the show cause. They participated. They accepted the jurisdiction of the adjudicating authority and as well as the issuing authority for issuance of the show cause. It was never challenged at any point of time. Now, when the adjudication order has been passed, it was pretty much in their knowledge that we have invoked the section 112 and we are asking for penalty under section 112 A1 and 112 B1. It was never challenged at any point of time.
Just answer one more thing. Come to page 440, line starting with the word however.
Yes, my lord. Well, this is the order passed by the Lineate.
No, however, what is I kindly read it, then answer.
My lord is showing page number
440.
Yes.
However,
However, we find that when the appellant is no longer the authorized representative for clearance of the goods after 5/11/2018, they cannot be held responsible for any offence committed by the subsequent customs broker appointed by the importer. Therefore, we observe that the appellant has not violated the provisions of regulations 10M. So this is for the purpose of adjudication for allegations under regulation 10M and 10N of CBLR.
correct. You are correct. But the basis of this finding is they cannot be held responsible for any action taken after 5th November 2018. Admittedly, whatever has happened after 5th November 2018.
So there were actions subject to correction, my lord. I will see to it. There were actions which were prior to that also.
Show me that then from paragraph page 94. That was actions was prior to that.
Statement over the page number.
Malad is at page 94.
Page
Kindly see the first paragraph of page 94.
Yes.
Kindly see the first paragraph. Dada. The alleged incident is of 30th November 2018 in the hand of CB IWW. And the first paragraph at page 94 talks about the fact upon getting no objection from import bond section, the subject goods were received and loaded by his company employee at CWC Kolkata warehouse on 30 November.
Very well, lordship. Kindly.
I was resigned. I resigned from the job from 5/11/2018. I made it a point in my reply in the subject show cause notice. He does not even bother to care.
No, lordship kindly comes to page 374. Lordship kindly appreciate the statement made by them under section 108.
Yes,
Lordship kindly
what?
comes to page 374.
I said that I have done that.
That is to be.
You know what is that?
Lordship,
370.
yes, my
This guy.
lordship kindly comes to page 374.
Yes.
Yes. Now, lordship, this is the statement made by the authorized person
Yes.
of the said concern.
Read it.
Now, lordship kindly comes to the second point number 2.
Read it.
On being asked if he facilitated into bond of bill of entry number such and such dated such and such for importation of such and such black pepper filed by Messrs. Arjus Spice and Food Trading Company, IEC number have such and such. He stated in the affirmative and stated that they had facilitated this filing of above 2 numbers of bills of entry. And after
that is
taking
their
from
case.
space. So therefore, they're in.
Then no, they have taken steps for bringing this and in the bonded warehouse. That is recorded in the order passed by the tribunal. You come to this particular paragraph,
At page 4.
paragraph number 2, briefly stated, the facts of the case are that the appellant was authorized by Ario Spice and Food, Ario Spice and Food Trading Company for importation and clearance of goods declared as black paper such and such. Accordingly, the appellant filed 2 warehouse into bonds. Admitted position.
So these are the
This position will not change. You
Hello,
cannot say, no, I have not done
Well,
this.
let this statement be continued and come to page
I have
376.
read this.
376.
Which one?
This statement, my learned senior friend was showing 374. My statement,
Yes.
correct? It is continuing. Kindly come to 376. The last paragraph.
no, before that, Lordship,
No,
also
no,
kindly
no.
sees the transaction which has happened.
What transaction?
Yes.
happened?
Acha, let
My
us,
turn,
let
let
us.
me submit. He has already.
Acha,
admitted.
let us.
Now,
It's guiding.
my lord is there.
Yes. On being asked if he has authorized from importer such and
On
such.
being shown the account statement of importer as visible as per the records, total 11.5 lakhs rupees was transferred in his farm's account. He was asked to explain the same and provide the details of expenditure. He stated that if it is transferred, then he will check the bank statement and the invoices, and both will be submitted shortly. Thereafter, not submitted. Again, subject to correction. They have seen importer statement of bank account.
Kindly read the next part.
Yes, I will read the next
Read
part
it,
also.
read it,
Next
please.
part is part of record. I have nothing
Please.
to hide.
Here you are not read. Why are you hiding?
So involvement is there. For that reason, we have initiated the proceeding under section 28 for recovery of the duty foregone as well as for penalty.
Is this a
Now,
final?
Lordship, the finding that my learned friend is showing in the impugned order, maybe the finding of fact is incorrect. But incorrect finding of fact, even assuming or not admitting, it doesn't give him the right or the jurisdiction or the authority to come before this prerogative jurisdiction challenging by filing an application under Article 226. A wrong finding, it has to be challenged before the proper appellate forum. It is not, if a wrong finding or wrong reasoning has been assigned, that doesn't mean there is a lack of jurisdiction. It's only it has been filed with an oblique motive to preempt his client from paying the pre-deposit.
I am paying here and now before this line honorable court. 10%, not 7.5%. I'll pay 10%. Your
Ashok.
lordship can direct me to pay 10%, not 7.5. There is no such motive.
It appears that in the order
to file appeal. Otherwise, also section
Very-
14 is available.
Very. Since this court is refusing to entertain the, yes, Mr. Mehta, refusing to entertain the petition on the ground of alternative remedy, I am of the view that the petitioner should be afforded, and the time has expired.
In the meantime,
And since the time has expired, time to prefer the appeal has expired in the interregnum during the pendency of the petition, comma, in the event the petitioner files an appeal in accordance with the files an appeal after complying with all formalities within a period of 3 weeks.
whatever your lordship does,
No, I am asking you if for you
it is otherwise ready. I will just change the
in a
form.
period of 3 weeks from date, the appellate authority shall accept and hear out the appeal on merits,
But one more,
subject to petitioner complying with other formalities. So,
one more indulgence. My license may kindly be started in terms of tribunal order. Tribunal has restored my license.
Yes.
Till date, they have not allowed me to
That
work.
That is not,
There is
you
a
have,
different
there's no
course of
prayer
action.
for that.
There is a different
The
cause.
prayer for that. No,
No, I have not.
then make come a prayer. I would. That is a different
I'm
issue.
coming.
So I would not hesitate to pass an order there. But so far as this case is concerned,
My lord was looking into that paragraph 13. Kindly see once. paragraph
13 I
12.
have seen, and the intelligence part that is recorded.
Kindly see paragraph 12.
So no. So
What
I
was
have
the
to
date?
go into. I have to go into that issue.
What was the date?
So someone has to go into
30
factually.
November.
Anyway,
30 November was the date of removal from Kolkata warehouse. How I come into picture? That is the whole thing.
you go
Anyway,
before the tribunal.
anyway, right. I just wanted.
I have recorded these contentions, although
I
this was in your favor.
was.
I was minded to, but considering that intel part, anyway,
My lord, I was just intended for your interference that adjudicating authority should not work mechanically every day.
let us see, sir.
That
Yeah,
your lordship will
let us
find
not-
in every case.
Next, call the next matter. Just a minute, I'll just correct one order.
Yes, Lord. This is the matter of the last occasion. This tribunal has dismissed their application. On 2nd of April 25, this court directed that after the order passed by the Commissioner of Appeal in the year 2024, all damage charges shall be paid to him. The tribunal said this, that I am free to take these goods. But I made a statement to the before the court that I will be moving these goods as they want because it was subject to the order passed by the tribunal. So the tribunal dealt with that part of the order which I placed before Lordship Miller. That is at the paragraph 5 of that.
Yes, email was given. What happened to that?
Yes.
What has happened, my lord? The next date of hearing, which is for the final hearing, is on 23rd.
No, no.
No, no.
So I was.
That we cannot stand in the way. Have you taken a decision?
Sir, they have made a submission that they will be removing and to that effect, they have made an application and approached.
No, have you taken a decision?
Yes, yes. Well, we have intimated them by our letter dated 4625, which I have shown to your lordship on the last occasion. When
After 12th June, email communication, 12th June, I directed you. Arey, Mr. De, what is this? 17th June order is there. You have not seen the order. Mr. Bhanjo, you could assist your senior in this.
you have seen, my lord, there is no further instruction from the department.
Then let the officer come tomorrow. Whosoever is
Well,
instructing.
what I am submitting, Madam,
Yes.
this the matter will end after this stay has been. First, they were asking for
I understand
stay.
that,
So
but-
I will remove these goods at his risk and cost. That's all. I am doing it.
Let his officer come tomorrow. He will be in difficulty. Tomorrow he'll bring his office. I'll direct. Since today, Mr. De Lanet advocate represent. Why? Because of the demerit charges. I've recorded that. Demerit charges only. That is the reason. Unnecessarily. That is the reason.
Yes, and damage charge for will this futile damage charge will be 45 lakh
No, no.
for a good
For
which
a
has
good
no
for
value.
4 lakhs. What?
No value, no value.
No value.
Now it is no value. They are earning, my lord, the sport authorities. And let's
My
say
lords, I appear for the petitioner in
Mr.
item number 3.
Hearing.
My lords, on the last occasion, my lords have directed me to serve Mr. Somin Bhattacharya. My colleague had served him, my lords.
Password.
Very good.
He's here. Continue. He's here.
My lords, the petitioner is challenging the reassessment order passed under section 147, read with 144B of the income tax on the grounds of violation of natural justice. My lords, I'll just make 2 submissions. Firstly, my lords, due to circumstances beyond my control, I could not file my reply to the show cause notice dated 31st January 2025 as a result of the fault of my own accountant. It was an inadvertent error. He had stated the lapse before a magistrate, and within 15 days we approached this court. My lords, the important point here is that the impugned order does not take into account the detailed reply filed by me dated 4th November 2024, wherein, my lords, I had furnished an important document which was annexed with the reply and had also pleaded with regards to the proceedings in my previous assessment years, my lords. My lords, in my humble submission, these were materials on record.
Order, sir. This is an appealable order.
My lords, but kindly appreciate, my lords, I am kindly hear me for 2 minutes, my lords. My lords, these were materials on record which I had furnished before the authorities, suggesting otherwise than what was concluded, my lords. And therefore, my lords, in my respectful submission, contrary conclusion couldn't have been arrived at without disregarding this evidence and completely ignoring this evidence, my lords. This was completely omitted by the impugned order, my lords. And on this point, I am backed by a judgment, my lords, is well aware by Justice Sanjeev Banerjee, my lords.
What are you saying is well settled.
Yes,
No
my lords.
disputing that. He ought
Yes.
to consider it. But who will do so? Not this court, sir. The instant writ petition has been filed inter alia challenging an order passed under section 147 read with section 144B of the Income Tax Act 1961 dated 20th March 2024 for the assessment year 2015-2016. Mr. Full stop paragraph. Mr. Lakhotia, learned advocate representing the petitioner, would submit that in the instant case, although the petitioner had relied on several documents, such documents had not been considered with the appellate by the adjudicating authority, by the assessing officer, faceless assessing unit. What is this? Is faceless.
Yes, ma'am.
Of this apart, according to him, though there had been a default on his this apart, although a notice of show cause was issued by reasons of failure on the part of the accountant, such show cause notice could not be responded. Full stop. Paragraph. Having heard the learned advocates appearing for the respective parties and noting the materials and record, I find that the aforesaid order are passed under section 147 of the passed under section 147
Yes.
read with
144B, my lords. Page number 120.
144B of the said act is an appealable order. Full stop. The petitioner has an ample opportunity to raise all questions as the petitioner seeks to raise in the instant petition. Full stop. It is true. It is true that the assessing officer, faceless assessing unit is bound to consider the points raised by the petitioner. However, the same, in my view, cannot form subject matter of challenge in a writ petition. Full stop. In view thereof, the writ petition fails and is accordingly dismissed. Full stop. Dismissal of the aforesaid writ petition shall, however, not stand in the way of the petitioner filing an appeal. If so advised. You are out of time or within time?
Yes, my lords, I'm out of time. I came in time, but
Filing an appeal. Full stop. However, considering the fact that this matter has been pending before this court since 6th March 2025, I am of view that in the event the petitioner prefers an appeal within a period of 4 weeks.
4 week, no.
The appellate authority shall hear out 4 weeks from date. The appellate authority shall hear out and dispose of the appeal on merits. By taking note of all points raised by the petitioner, subject to compliance of formalities by the petitioner.
I'm grateful.
Next. This is Qatar only. Fail. Next.
Wait, please, Your Lordship.
Fail.
Lordship, I'm appearing on behalf of the writ petitioners here. Lordship, by means of this writ petition, I'm challenging the 148 notice passed by the jurisdictional
Rajesh. I'll come back in 5 minutes.
Lordship.
What do you do? Some bullets.
Lordship, the 148 notice passed by the jurisdictional assessing officer uh, appears on page number 29. Lordship kindly sees.
Yes.
Lordship, praying for a stay on such order. Lordship,
Which page?
page number 29, Lordship.
Did you respond?
Lordship, we did not participate in the proceedings.
Yes. Challenging the order passed under section 140
affidavit of service. Lordship.
না disprove করছি না।
Just to keep pending, my lord, because your lordship has admitted the matter. So yes, your lordship has to hear out the direction for affidavit. No, it's not required, my lord. Lordship will kindly fix the
Beginning of
matter.
this full stop. Let affidavit in opposition to the petition be filed within 6 weeks, reply 4 weeks, liberty to mention.
Great.
My lord.
Great.
The challenge is still there, no?
Yes, yes. Next service.
So many matters have been admitted.
Yes.
I can't throw away. Next.
But merit is very, very, very weak, my lord. The merit is, my lord.
Great.
Lord, I am appearing in item 5.
Yes.
My lord, in this case, 154 order has been passed in the name of the dead person, and the department was informed immediately after the death as well as after the so cause notice. My lord, can see the death certificate, which is at page 36. Page 36, my lord. And at page 35, there is compliance on the portal. Immediately, the assessee expired on 20th of March 2022. My lord, page 36 read with page 35. Way back in 22, the assessee had expired, and on the portal, the requisite compliance was done, attaching the death certificate. Thereafter, my lord, a so cause notice was issued under section 154, which is at page number 29. And in reply thereto, at page 31, the AO was informed once again about the death, enclosing the death certificate. In spite of that, my lord, the order has been passed in the name of the dead person, which is at page number 34, my lord.
I have asked for the instruction from the assessing officer. He has not given me anything in writing.
What
but
you will give?
But he has given me.
Unless you say that this is fraud.
That's why I was submitting. Give me some documents from where I have ascertained that they were.
Intimation is his show cause, response to the show cause. Ashun. Challenging not under section 154 of the Income Tax Act 1961, dated 2nd May 2024 for the assessment year 2013-14, but also the order under section 154/147, dated July 2024 for the assessment year 2013-2014. The instant writ petition has been filed. Full stop paragraph. Mr. Agarwal, learned advocate, appealing in support of the writ petition by drawing attention of this court to the show cause notice and the response filed by the one of the legal heirs. The legal heir
My lord, daughter-in-law is
by,
not one of.
by the daughter-in-law of the assessee would submit that as on the date when the notice was issued under section 154, the assessee had already died, and such fact was had died. First of the aforesaid fact would corroborate from the death certificate of the assessee as appearing at page 36 of the writ petition. Full stop. Records would reveal that petition. Full stop. Having heard the learned advocates petition, full stop. According to Mr. Agarwal, the assessing officer, notwithstanding being aware of the factum of death of the assessee, had proceeded order impugn. Full stop. Paragraph. Having heard the learned advocates appearing for the respective parties, no, pass the order impugn. Full stop. The same is not sustainable in law and should be set aside. Full stop. Paragraph. Having heard the learned advocates appearing for the respective parties and noting that notice was issued under section 154, the assessee had already died and the factum of death of the assessee was brought to the notice of the assessing officer. In my view, that the order, the order passed by the assessing officer cannot be sustained. The same is the order passed by the assessing officer under section 154. It is 24th July 2024 for the assessment year 2013-14 cannot be sustained. Stop. The same is accordingly set aside. Same is accordingly quashed. Full stop. Quashed. Full stop. The aforesaid order shall, however, not stand in the way of the respondents from taking recourse to law against the legal heirs of the deceased. Full stop. Mr. Agarwal is directed to communicate legal heirs of the deceased. All the legal heirs of the to Mr. Sharma, learned advocate representing the respondents in course of the day. Okay. No. To the assessing officer. To the assessing officer. To the assessing officer.
Within a week, my lord. Within a week.
Within a week from
Obliged.
you communicate the name.
My lord, I will.
So they'll take steps. I'll set aside the order.
Deeply obliged.
The aforesaid order shall, however, not stand in the way of the respondents in proceeding against the legal heirs of the assessee in accordance with law. Full stop. In accordance with law. Full stop. Oh, you'll be sure. Then already the who is the petitioner?
My lord, let the communication be done by the petitioner. I will forward the order of my lords to the petitioner that he comply with that.
Directed to communicate the names of the legal heirs of the
representative assessee.
Legal heirs of the assessee to the assessing officer within a fortnight from date. Within a fortnight of receipt. Within a fortnight from date of the receipt of the server copy of this order duly downloaded from the official website of this court. So communication by the persons, he should have some more time.
That is not.
They have 4 years to pass rectification order, fresh rectification. 4 years time is there, so the revenue is not affected at all.
Legal heirs, this part I last line the Diona. Because there is an issue. Who will be the legal heirs or not? Someone who has to.
That's why there will be a representative assessment.
That we have already informed them in the portal. That compliance.
Last part. Petition communicate to get it. Next.
Deeply obliged.
The department will be at liberty to take further action.
That I said so, not stand in the way. That part is there. But further direction to communicate, I am not necessary. Disposed of. Yes, next.
Lordship, Mr. Shomin Bhattacharya is appearing for the respondent. Your Lordship,
You are there, madam? Yes, next.
instruction.
Call the list. You are there. File the. I have not passed it over. Place your case. Where is Mr. Bhattacharya?
He is engaged in another courtroom. Your Lordship, kindly pass over.
Which court?
in 551, Your Lordship.
Very well.
Very little.
Pass over. She doesn't want to do it. Pass over. Next.
Madam, for the petitioner. At last occasion, this matter was heard, and your lordship has been pleased to pass an order that I am claiming my goods to be returned to me in view of the order of the learned tribunal, and they are not yet releasing my goods.
Yes, I'm directing release
But I am,
forthwith. You cannot prefer an appeal.
no, no. Well, I am told that my lord, process is going on, my lord. Some documents were sought from the my lord, petitioner.
Arey, what documents you will require? You have confiscated this wrongly. It has been set aside, Mr. Bhattacharya. You
Accepted.
can.
My lord, commissioner accepted the order of the seated, my lord. Now, my lord,
There's no question of accepting. He has no right to prefer the appeal today.
well, now, my lord, their department is processing for reading the goods, my lord. Along with
Very well. I'll direct you to do it within 15 days.
Lordship,
Very well.
my lord,
The
only
incident petition has been filed inter alia praying for a direction upon the respondents to immediately release the gold ornaments
indulgence, and I had a prayer for refund of the pre-deposit consequent to.
Yes, yes, without.
In that event, he need produce certain documents.
It is our matter that in the event the petitioner has filed any pre-deposit, has had made any pre-deposit for maintaining the tribunal will not give this order.
No, my lord, tribunal has passed the order. My lord will kindly produces the order with consequential relief, if any. My lord, the consequential reliefs are entitlement on the gold as well as on the pre-deposit.
No, sir.
Yes.
So the assisted.
My lord will kindly.
Have you asked for prayer?
Yes, I have prayed for.
No, where is that prayer?
My lord, prayer A itself.
No, prayer in the writ petition. What about your assisted appeal? Where is the state petition? Where?
Appeal pre-deposit is
Deposit is
mandatory. He deposited. Now, my lord, if he wants to get back the money, he'll have to produce the document to the authority. But that apartment, if he wants to get the release of the gold, he will have to give an authenticated
my lord,
document.
till that the authority has not given any intimation. it will
Duly
be given
attested by the
for their
authority.
intention to release.
pre-deposit is deposited where?
Is deposited for the first time before the first appellate authority, second time before the tribunal. All those are cumulatively amounting to 10% in total of the amount of penalty imposed. My lord,
You ought to have indicated this before the tribunal.
yes, my lord, here it has passed. My lord will kindly see page 119. 119. Para 21. In the result, the appeals
Although
are
Mr.
allowed.
Chaudhary, learned advocate, this apart, although Mr. Chaudhary so far as consequential relief is allowed, therefore no separate order is necessary, therefore they shall be entitled to the refund of the pre-deposit in accordance with law. But you cannot you cannot ask them, come to my office twice, or that's on the fourth occasion I will give you, provided this is there. That should
Instead of
not
Mr.
happen.
Chaudhary or some other Chaudhary came, give me the gold. Then
That
what
is all
department
right.
will do?
That the department
I
will
have
verify.
provided for that, even including the
That's a document required. Well, he will have to come with the Aadhaar card, all these things.
transfer of the pre-deposit will be on the bank account basis. Nowadays, no cash money is transacted. You will transfer to his bank account directly.
The money. But
Yes.
regarding gold, man, regarding
Gold is different. Gold already I
Mr.
provide.
Chaudhary will not come. Somebody else will
No, the
come.
petition
Naturally,
itself will-
naturally. You test it out and get an hand over.
That's why I'm saying
Call the next matter.
Lordship, here I am challenging the appellate order. It was passed ex parte. Lordship, I was not
Who's appearing?
last occasion also I was directed to pass.
Action. State. Today is a holiday. Only appellate side matter, or they will appear. Act 2 I'll take up. No, Act 2 is not possible. Tomorrow. Tomorrow means Monday. Yes, not today. These are not today.
Lordship, mention.
Monday. Dekh.
Lordship, I'm appearing on behalf of the petitioners. Lordship, certain instructions are forthcoming from the clients which will help us in addressing this court. I was praying for a week's adjournment. Like any day next
Since
week,
an
any day
accommodation
next
has
week,
been
Lordship.
sought for on behalf of the petitioner, let this matter go out of the list. You mention, I'll take it up. On your side. Let it come back whenever he comes, otherwise unnecessary list is there. Original side, there is no difficulty in entertaining matters.
Only one thing, your Lordship kindly records that this will not, pendency will not create any kind of
Go out of the list, what more? I'm not retained in the list, directed to go out, enough. The other matter was a touch and go matter. You argued that matter. I only convincing argument was the scope of the appeal in this case and in the other case. Anyway, already passed the. ডাকো 1:30 অবধি গেটটা অবধি বসবো। Yes.
That this is a protective assessment order passed and report sent to the valuation officer for valuation. Without receiving the valuation, assessment officer passed the assessment order.
Where? Show me.
Kindly look into the page 52, my lord. Last two paragraph. Page 52 of the petition, my lord. Last two paragraph. It is pertinent to mention that the case is covered under provision of section 56
Proviso
with section 56 2x of the act given above. The assessee the fair market value of all the 14 properties. The case is referred for valuation to departmental valuer officer under the section 56 of the Income Tax Act 1961 on 29th August 2022. Since the valuation report is not yet received and the assessment is getting time barred on 30th September 2022, the assessment is being finalized on the basis of the material available.
Right to prefer an appeal. Prefer an appeal? Yes.
I prepared appeal.
Where? Which paragraph?
It is 56. My lord, I come before the read court with clean hands. I prepared appeal.
The challenging.
My lord, just one thing.
Yes, challenging the assessment order
The penalty order has already been passed.
Yeah, I'm dismissing it. No, no further. Good.
But they deducted my entire amount.
I've just, you want me to impose cost? Dakho, point it out.
Please, Your Lordship. Very peculiar situation, my lords. I open my portal and I see there are 2 demand notices. I do not have any documents prior to that. I write a letter to the ITO. I say they ask me that I should contact with the CPC. I write a letter to the CPC. I get a grievance resolution saying that they do not have any supporting documents to that outstanding. It could be an error on their part, my lords, is what I have. The documents might show.
Where?
Lordship will kindly.
In order to raise argument, I have got instruction. I have been to the assessing officer. Whatever they have done, they have confirmed that
Yes.
they are allowed as.
That is one part.
So I have got instruction. Why nothing is being done? Managing sometimes so that.
Very good, very good. No, not today. I'm not recording anything.
Lordship, Lordship,
Ante dao dao.
Lordship will just see one.
Take action.
Lordship will just see that one page, page 57. Page 57, Lordship will just one see. That is what will help my learned senior friend also to take an instruction. Page 57, my lords. The grievance resolution. No such order has been found in the
The present
ITV
lead
system.
petition has been filed inter alia. For
Instruction manual, but there has been some transfer of officer.
No,
August.
July.
August. No, he says August.
August.
No, it's all right, but pilot,
July is okay with my.
July. Very good.
I'm so grateful, man. I'm so grateful.
Next.
Item number 12. My lord, I am appearing for the petitioner, my lord.
Yes. Yeah.
My lord, in this writ petition, I have challenged the notice issued under 148 by the jurisdictional assessing officer, my lord. Kindly come to page number 13 of the writ petition.
Challenging the order passed under section 148 issued by, under section 148 dated 25th August 2024 for the assessment year 2018-2019.
the notice was issued on 25th of August 2024.
The instant writ petition has been filed. Most of the petitioner contends that the jurisdictional assessing officer, having regard to the scheme being notified pursuant to section 151 of the Income Tax Act 1961, hereinafter referred to the said act, is not entitled, is no longer authorized to issue the notice under section 148 of the said act. Post of having heard the learned advocates appearing for the respective parties, I find, now I am of the view, I find that the petitioner has failed to afford any appropriate explanation for the delay in approaching this court. First of having regard thereto, I am of the view no is called for. Full stop. Let affidavit in opposition to the instant writ petition be filed. Now called for. Full stop. Called for.
My lord, my only prayer that we have filed the writ petition long back in the month of January or February, my lord.
Sir, filed in 10th of April. Called for. However, since the jurisdictional issue has been raised, the writ petition shall be heard. Full stop. Let affidavit in opposition, such and such. Next.
My lord, one thing, my lord. Section will be 151A, capital.
Yeah, ওটা তো আগেরটা 151 capital.
Capital.
I'll check it when before signing.
It can be done now, my lord.
আগেরটা ভেঙে নিয়েছি। ডাকো দাও পরেরটা দাও। Yes. Password. Password. Not today. Gusham, not today. Go. Password, not today. Not today. পুরো লিস্টটা ডেকে নিয়ে আস্তে আস্তে করে একবার পুরোটা ডেকে। If the petitioner, both the parties are there, I'll take up. But let her call so that at least the matter be called on. It's not being called on. Yes. এই যত অব্দি হচ্ছে না পরের দিন তারপর থেকে ডাকবে, ঠিক আছে? ইয়েস। ঠিক আছে, ব্যাস 20 অব্দি থাক। অমনি ম্যাডাম ইউ কল ফ্রম 20 on Monday, ঠিক আছে? Record in the list that matters shall be called on from item number 21 on. But the others will get a chance. They will be called on. Nobody is there.
My lord, I was there in item 16, my lord.
My lord, item 17, I was there, your lordship.
Very well. I shall see you. We'll get a chance again. Next week, this will be all from 22 onwards. From 22 onwards.
My lord, some urgency is there, so it may be taken up next week.
Yes, pass over item number 6. Yes, who is appearing? Item number 6, passed over. Matter is over. 551 came running. Why did you come running, Mr. Bhattacharya?
Your lordship passes over the matter, my lord. I have
It's a long 5th floor. I remember I used to sit in courtroom number 550. Where is the petitioner? Mr. Chatterjee was appearing after he lost that matter. Very well, not today. No, today goes. I'll touch password. Yes, 13 who's appearing. Oh, not today. ঠিক আছে, আর কিছু নেই তো?
Item 16 may be taken up next week, my lord.
No, those have been called on. I'll call on the rest next. From 20 onwards, thereafter again I'll come back, sir. No difficulty. I'm giving them an opportunity.
I was online, my lord. It was not, I did not hear the call.
Your lord, the list cannot be heard, your lordship.
You mentioned the dekhe.
Daily list item number 1.
My lord had fixed that matter.
Lordship said.
We mentioned late. Wait. This is a two mentioned matter.
For
Not
correction,
fixed the date. Wanted
for
to-
correction, yesterday's order.
No, no, it's not a to be mentioned matter. My lord had called us because my lord had fixed that matter on 25th June, 2 p.m. My lord, then there was DB, I guess, my lord, on that.
There's a division bench.
No, any day, like 3rd July or 7th or 9th July.
There is no oral order. There is a formal order written recorded. No.
No, 3rd July or 7th or 9th July because my lord takes mostly on
It was
Mondays or
initially fixed on
Wednesdays.
26th,
25th.
5th or 6th.
25th.
25th.
Then let it go to second.
The second, I have difficulty, my lord. I've told if it is on third, subject to lordship.
Third, not possible. These are the other matters. Second, or else the next week.
Coming.
Then it will go after then a month.
My lord, ninth.
Make it 9th one. Make it 9th.
Let it appear in the monthly list. I'll take it up on 9th.
But let it come up on 9th by an order, my lord. Otherwise, it will not come up, my lord.
Monthly list diye dao, 9th diye dao.
Mark kuda.
But it will be marked in the monthly. At 2 p.m., my lord.
Number taliki.
Marked
Let's see. Let it be marked 9th. We shall see.
But if it's marked at 2 p.m., my lord, then it's more certain, my lord, because morning, my lord, mostly it's
The motions are taken up to second half, PM or 3 PM, whatever.
3 p.m. করে দিও 9th দিয়ে ঠিক আছে call the list.
But for correction, can I mention yesterday order uploaded?
Mention item number 1.
For the petitioner, my lord.
Mention tomorrow morning. Tomorrow morning, Monday mention.
Your lordship,
Hand over, it will appear in the list. Hand over. Yes.
my lord, your lordship wanted to ascertain whether I have paid the 20% of the tax as directed.
Very well.
This is the letter they have given to me.
এটা 2 নম্বরটা তো
Since the learned advocate represents the petitioner by placing before this court the communication
Well, second is also same. My lord, I have also.
entire amount has been paid. Entire tax.
Well, this is the
same identical order. Fee is already over 10:30.
well, I have given hand over a copy of the letter they have issued.
Hand over the letter, second matter.
Hand
Yes,
over.
for the same order. Yes, call the 2 p.m.
Answer the sir. Sir. Item number 4.
for the
You are appearing in this matter.
Yes.
Yes, yes.
Attorney General is out of station. Attorney General of India is out of station.
I see.
I will appeal.
Yes, yeah, you always, sir. You're welcome, sir. Yes.
In this petition, I'm challenging the regulation 5 and 6, wherein basis this regulation, the customs is asking cost recovery charges of the custom officers who are posted in my CFS.
Hey, ওখান থেকে দেখো customs এর manual
My compilation I have already.
We have annexed it. Very well, sure.
My compilation it is there, Your Lordship. This
Very
is the
good.
first challenge. Second challenge is, Your Lordship, without precise.
Where is it? Where is it? Which page? Which page?
Your Lordship, on the last occasion, I had circulated a compilation, page number 6 of my compilation.
Yes. What is your challenge to this?
Your Lordship, if you see the regulation 5.2, it reads. This is page number 6 of my compilation.
Yes.
Undertake to bear the cost of custom officers posted at such customs area on cost recovery basis by the principal commissioner or commissioner, as the case may be, and shall make payments at such rates and in such manner prescribed, unless specifically exempted by the order of Government of India in the Ministry of Finance.
Yes.
So basis this, the commissioner is asking cost recovery charges for the custom officers who are posted in my premises.
Yes.
I'm a CFS.
Yes.
Custom officers. So my challenge is this, that this regulation is ultra vires the act, because this regulation came into the picture because of a section under the Customs Act, wherein the Customs Act does not provide for cost recovery charges. So how can a subordinate legislation override a parent act? That is my first challenge.
I see.
Because this regulation came into
The Customs Act does not
provide for cost recovery charges. When the parent act does not provide for cost recovery charges, a subordinate legislation in the form of regulation cannot recover.
That is your first point.
That is my first point, Your Lordship.
Just identify the points.
That is my first submission.
No. That identify your points.
Yes,
What are your points?
Yes, Your Lordship.
Because you see, there is no scope for passing any interim order in these matters.
There is a scope, Your Lordship, because they are again and again demanding cost recovery charges for the custom officers.
So till such time I declared this as ultra vires, can I pass any interim order in
Yes,
your
Your
favor?
Lordship. The answer is yes, because identical matter was argued by me today, and ad interim was granted, Your Lordship. I am placing that order also by Telangana High Court, Amravati High Court division bench decision.
No, in a matter
Same challenge.
where a you may have secured an order from a particular court, but does law recognize prior to a provision being declared ultra vires?
This provision has
to
been declared
stay
ultra vires,
such proceedings, to stay proceedings on the basis of such
I'll answer
a
that.
regulation or a provision?
That I'll answer that, Your Lordship. Telangana High Court has already declared this provision as ultra vires. The matter is pending before Supreme Court.
Show me that
there is no
judgment.
stay.
Show me that judgment.
Yes, Your Lordship. It is part of my compilation, which Your Lords were reading. Seal number 16, Your Lordship. Page
On the ground that
this is
the regulation on the ground.
Same submission that the regulation is ultra vires the Customs Act, because the Customs Act does not provide for recovery of cost recovery charges. Page 38, relevant para of the judgment is para 17, Your Lordship.
So you're pressing this point.
Pressing this first point. There are other multiple submissions by me in relation to.
No, please identify what are submissions you will make, sir.
This is my first submission.
Yes.
Settled by the judgment of Telangana High Court.
Which paragraph?
17 onwards, Your Lordship.
No, particular paragraph.
17
Discussion may be in so many paragraphs.
17 and 20, Your Lordship. 17 to 22, Your Lordship. 38. Para 17, Your Lordship, my apologies, 42. 42. Relevant para is 20. Page 44, Your Lordship. Page 44. Relevant para is 20. May I read, Your Lordship? Thus, from the perusal of Section 158 of the Customs Act, it is evident that Section 157 does not enumerate any specific provision under which cost recovery charges, that is, amount of salary payable to the officials of Customs Department who are deployed at the airport who perform their statutory duties, can be recovered. The 2009 regulation has been framed in exercise of the power conferred under Section 141 and Section 157 of the Customs Act. From the close scrutiny of the aforesaid provisions of the Section 141 and 157, it is evident that there is no express statutory provision conferring the authority on appellants to levy cost recovery charges. In absence of any special authorization to levy cost recovery charges, appellants have no authority to impose cost recovery charges by means of regulation. The inevitable conclusion is that the regulation is ultra vires the Customs Act. Exactly my submission.
Not regulation. This particular
regulation was challenged.
5.2 is ultra vires.
Yes, Your Lordship. 5.2, exactly the same regulation was challenged, Your Lordship. Lordship, the first para of the judgment, it says 5.2. If you see what was under challenge in that judgment.
You see, Police Act also does not provide for this, but regulations provide.
Your Lordship, custom officers are doing sovereign function because they are not providing services to a CFS. I am a CFS, I am a custodian.
So this is your only point.
No, no, Your Lordship.
Second point, sir, argue your point.
This is my first point, Your Lordship.
Yes.
The second point, Your Lordship, is that if the cost recovery charges are considered as a tax or fee, those tax or fee cannot be collected for sovereign function.
Cost recovery charges cannot be a tax. Cannot be under any stretch of consideration.
Assuming,
why assuming? Sorry, either you make out your positive case.
Yeah.
Don't proceed on the
Because
basis of
department
conjecture and
there are
surmise.
negative- there is a finding of.
I've seen that on the next paragraph.
Yes, Your Lordship.
But
That's
are
why
you
that's-
trying to suggest that the cost recovery charges are to be construed as a tax component?
No, Your Lordship. I'm
Then-
not arguing.
Then don't argue that.
If I am, then I'll argue that it is, if it is a fees, because that is the case of the department. If it is considered as a fees, because tax and fees are two different things, as held by the Supreme Court, I'll point out that decision. Then fees cannot be collected from a CRC, that CFS, because fees can only be collected when there is a
That is
quid pro quo.
presuming either it is a charge or a fee.
Correct, Your Lords.
Now, as per the regulation, it is a charge. It is not a fee. Now, we'll find out what is the distinction between the charge and a fee, but this is certainly under the regulation, not a tax.
Very
So,
well.
if this is not a tax, so the question of recovery of tax without the sanction will not arise. That argument is not necessary here.
Then my submission would be that can it be collected without authority of law? The answer to my mind is no,
No,
because
let
there
us
is no
not go that
sanction
far.
for
Let us not
another-
go that far. Let us not go that far.
So for fees part, Your Lordship, my argument is if the department is arguing that it is a fees, then Supreme Court has held that fees can only be recovered when there is a service provided by the person for collecting that fees. In this case, custom officers are not providing services to me. They are doing a sovereign function. Because I'm a CFS, I'm only a custodian. I'm only responsible for handling the imported and exported goods which are stored in my premises. Custom officers are posted in the premises for looking after the levy and collection of tax of the imported and exported goods. They are doing sovereign function. They are not providing services to me. As a CFS, as a custodian.
They are discharging statutory function.
Yes, Your Lordship, but I am a CFS. How can they provide service to me then? Because if it is a fees, the Supreme Court has held that the fees can only be collected if there is a services provided by the person who's
Come to 5.1.
of the regulation, Your Lordship.
Yes. Where is the statutory backing for providing these services?
There is no statutory back.
So therefore,
That's
if there is no statutory backing for providing these services, then you cannot say that the customs officer are discharging any statutory functions.
correct, Your Lordship. Absolutely right. So this is my second submission, Your Lordship. Third submission, Your Lordship.
No. Slowly, sir. I am not as fast as you are, sir.
My apologies.
So if therefore a customs officer is not discharging any statutory function, but is rendering services,
Then
whatever services is here provided for which they are entitled to this service, charge in the form of for providing services.
then I'll ask myself, Your Lordship, what services are they providing to a CFS?
Very well. This is your argument, general argument. Now let me get an overview from the. You see, today this matter cannot be decided.
No, Your Lordship,
Right.
I am aware of that.
I do not consider that any affidavit is called for.
No, Your Lordship, nothing.
But I want to hear.
Yes, Your Lordship. So I'm giving you an overview of this matter, Your Lordship. This is my second
I
submission.
want to hear the learned additional solicitor general on this. But this is not such a point which may require consideration for days together also, subject to hearing you. So, sir, what is your opening response on this? And then I'll fix a date.
I have firstly,
Sorry, Your Lordship. May I complete my third submission and then
Yes, sir, wait, sir, kindly wait. Let me
then he can give his response
Yes,
to that, Your Lordship. Then the third submission, Your Lordship, this regulation was notified because of one recommendation made by the committee, which was made in 2005-2006. The reason for those recommendation was there were some uncleared goods which were lying in the CFS, uncleared, unclaimed goods, and they were not auctioning the goods. Because they were not auctioning the goods, the revenue was the government was not obtaining any revenue, and there was a delay in auction of those goods. So the recommendation was made in 2000. It's part of my part 2 compilation which I'm circulating right now. Because prior, this regulation came in 2009. Customs Act is enacted in 1962. Why? So it's very important why this regulation came in 2009. The reason being.
Sir, where is the first page of this regulation?
Your Lordship, in my compilation, this compilation which I just said.
Yes, paragraph, page number 5.
Yes, sir.
Page number 6 is para 5, regulation 5.
Yes, sir.
Where is regulation 1?
Yes, Your Lordship, the second compilation just circulated.
So
now.
these are separately. Why then why are you circulating this?
So I missed that regulation. That's why I'm
You will
circulating.
not circulate the entire regulation?
I did not, Your Lordship. My mistake. My apologies, Your Lordship. Page 82. Page 82 is the entire regulation. My apologies, Your Lordship. My apologies. 82.
Yes.
Your Lordship, got it? It says, in exercise of the power conferred by subsection 2 of section 141, read with section 157 of the Customs Act, the Central Board hereby makes the
Yes.
following
You just
regulation.
place section 141 and section 157.
Yes, Your Lordship. That is in my first compilation. Your
Very well. I have that.
Sorry, Your Lordship.
It's all right.
It's my mistake, Your Lords. I should have
Place that.
been more careful. So page 2 of my compilation, page 2 is 141, sorry. Subsection 2 is there, Your Lordship. Page number 2, Your Lords, got it? So it reads, the imported or exported goods may be received, stored, delivered, dispatched, otherwise handled in a customs area in such a manner as may be prescribed. That is the first part. And the responsibility of the person engaged in aforesaid activity, that is the activity of storage, delivery, dispatch, shall be such as may be prescribed. So as per this subsection, this rule was enacted. So this subsection nowhere says about cost recovery charges. It only says that for activity of storage, delivery, dispatch, otherwise handled in the customs area by the custodian, the relevant regulation will be prescribed and his responsibility will also be prescribed only for storage, delivery and dispatch. It does not say about cost recovery charges. So that's why Telangana High Court said.
Slow. While I am to presume as a constitutional court that the provisions of the act or the regulations are not ultra vires.
Very good.
I am to presume ordinarily
I'll satisfy Lords.
that when the legislature has enacted them, having due regard to the other provisions, it has been enacted. So don't be so fast.
My apologies.
You highlight the points, thereafter we will test it out.
Yes, Lord. So basis this subsection 2.
Onus is on you.
Yes, Lord.
To establish that this is ultra vires the act. That is your first point.
Yes, Lord.
So what it says, all the conveyances and goods in customs area shall, for the purpose of enforcing the provisions of the act, be subject to control of the customs, officers of the customs. This is the first
subsection.
So this regulation has been enacted in pursuance to this particular authority vested with the customs officer.
Correct.
So without the customs officer, you are nowhere. You cannot conveyance and goods. Conveyance and goods are subject to their control.
Correct, Your Lords. Because I cannot clear the goods until and unless custom officer gives me an. See, I am a custodian, Your Lords.
They when as a clearing agent or as a CFS, you have to store it initially in the customs warehouse bond when you import it.
No, Lordship. So the practice is there are two. There is custom warehouse and there is a CFS, which is private CFS. The purpose of CFS was exactly for this reason, that the ports were getting congested, and India being a growing economy,
That is under the control of the customs.
both are under the control of the customs.
So therefore, once the goods come in,
Correct, your lords.
they are to be examined.
Correct, your lords.
Until such time they are
Such
examined.
In my premises, I'm
In
only
your
getting storage
premises.
charges.
So despite the fact it is in your premises, the customs officer have to travel to your place.
They are posted in my place, not travel. They are posted in my place, your lordship.
Because you have then your conditions of license is also required to be seen. You have been granted a license.
Then, your lordship, can a license override a section?
No, your conditions of a license are also required to be
Very well,
seen.
your lordship.
It is not that simple, sir, but just by saying that it is not there in the provisions. Whether it is there in the provisions, you have to find out.
Yes, your lordship.
Your argument cannot be that simple.
I
Very well.
understand, your lordship.
So I understand. So this is, and then come to 157.
157 is the next page, your lordship, page 3
Yes.
of my compilation.
Yes.
May I read yours?
General power to make
General power to
regulations.
regulations. Because
Yes.
2009 is a regulation
For what purpose? Let us see.
without prejudice to any power.
This is under which provision? Which part? A1, which one?
Nothing, your lordship. This is only an example given.
No, not example.
This is not an exhaustive.
May not an exhaustive, correct. May provide for the following matters. Which are the matters? Let us see
Yes, your lordship, one by one.
which will be the closest one. Have you checked up,
I
or you will be reading it for the
No, no,
first
I've
time
checked up,
before
your
this court?
No, your lordship, I have checked up.
Yes.
There is the closest one, because this is a general power given to the board to make any regulation, your lordship. And subsection 2 is just a example under which these regulations, examples of regulation which can be enacted, your lordship.
This does
This
not provide. This also does not provide for any charges.
No, your lordship, no.
Have you checked up this?
Yes, your lordship. In fact, in the entire scheme of the Act, of the Customs Act, nowhere it is stated that the cost recovery charges of the custom officers who are posted in the CFS has to be recovered from the CFS. Because the CFS, they are appointed as a custodian under section 45.
Where is the recommendation? According to you, this regulation was enacted
So, your lordship,
on the
paragraph
basis.
of my compilation,
Yes.
second compilation, lordship.
Yes. Where is the recommendation?
Recommendation is at page 37, your lords, of my compilation.
On the basis of the Public Accounts Committee report.
Yes, your lordship. 2005-2006.
Page?
Page 36, your lordship. Para 65.
Have you supplied?
Yes, your lordship, I have supplied.
Yes.
Para 65, lords. Under the extant rules and arrangement, responsibility of clearance disposal of goods lie with the custodian. The role of customs in disposal of cargo is to examine the status of the cargo and give permission to custodian who sought for under Customs Act. The committee are informed that in case of non-fulfillment of obligation by the custodian, the concerned commissioner can cancel the approval given to them to operate ICD or CFSs. However, no detailed rules empowering the customs to take any punitive or deterrent action against the custodian in such cases have been framed. Further, no safeguard for protection of revenue in cases of negligence or violation of conditions.
Yes.
So, because of this regulation came into. Only to protect the revenue.
Kindly come to regulation, the section 158 of the Act.
Section
158 of the Act.
I don't have.
You don't have an act, you have come to argue.
Your Lordship, I don't have. Yes, Your Lordship.
Yes, place it.
Provisions with respect to rules and regulation, Lordship.
Yes, place it.
All rules and regulation made under this act shall be published in the official gazette. Any rule regulation which the central government or board is empowered to make under this act may provide for levy of fees in respect to application, amendment of document for furnishing of duplicate documents, issue of certificate, supply of statistics, and for rendering of services by officer of customs.
Yes, that's it. Was this particular section noticed by the Telangana High Court?
But this regulation is not enacted under this section.
Doesn't matter. You said this is ultra wide is the act.
Yes, Your Lordship, but this regulation.
Is
does
it ultra wide is the act? I want to understand from you. I'm not coming to conclusions. I am neither expressing myself. I am discussing aloud with you so that you get an opportunity to respond. Have you made research on this?
So my answer to that, Your Lordship.
Have you made research on this? Yes.
Let us read this subsection, Your
Yes.
Lordship, to understand what it
No,
says.
does it provide for
No, Your Lordship.
fees?
No, Your Lordship, not for cost recovery charges of custom officer posted in the.
It provides for fees
For
by officers of customs officers under the act.
Yes, yes, Lordship.
Well, I'll hear you.
For my.
Get ready in the matter. Get ready with authorities in the matter and come back on the next day. I'll hear you. Yes, sorry. Yes, sir. Yes.
I have a preliminary objection, a technical objection.
Sir, I'll hear out the matter unless you say the technical operation is so serious that it should not be.
This has been done, affirmed, is an admittedly a company, how the cost detail has been set out, kindly sir. Whether a chief operating officer can maintain a writ petition without the resolution of the company, and what is the cost detail?
I'll check up that on the next occasion. I'll keep it open. I'll keep it.
I am asking for submitting.
Since you are here, I'll get the opportunity to ascertain from you the legal stand also.
That apart,
Yes.
he has submitted that the decision of the Telangana High Court is now pending before the Supreme Court.
Yes, sir.
And now this matter is pending before your lordship. Article 139A of the Constitution provides when there are multiplicity of proceedings in different courts on an application made to the Supreme Court, the entire matter will be transmitted to Supreme Court for a decision. That aspect is there. Second is
that
aspect is left over.
Yes.
That second is that the decision has rightly failed from your lordship. This matter has to be interpreted not only on 157, 158, but the regulation is also framed under 141. This is procedural simplicity. But whether this petitioner can approbate and reprobate by time and again depositing these charges and making application for exemption for a long time, whether he can approbate and reprobate. Now he has become wiser to challenge the virus after submitting before the jurisdiction, paying time and again all these charges. These are the documents. Therefore, this question of maintainability has to be left open. Third, the latest view of the Supreme Court is prima facie. I'm not taking losses.
No, naturally. Today, I will not decide it. Because he has
as rightly fell from my lord, there is a distinction between a challenge to the general statute and a challenge to the fiscal nature of a statute. Supreme Court's view is court will be very much slow to strike down a fiscal nature statute. In other aspect, the view of the Supreme Court is it must be unconstitutional. The difference between our constitution and other constitution is that the American constitution can declare a law ultra vires simplicities or arbitrariness. But it has to be absolutely unconstitutional. Not only ultra vires the statute, but it has to be unconstitutional overall, basic structure, fundamental rights and other issues. Therefore, prima facie has rightly failed from your lordship in our court. He has paid, he was paying for the last few years. There is no scope for an interim order because he
No, interim order, I'm not minded to, so you need not argue. I'm not minded to pass anyone. Yeah, I'll fix it up. But there is also no scope to file any opposition. Also, no scope to file any opposition. No, certain. Because whatever they want to say, you tell me.
We are not filing.
You are leading everyone, sir. Since you are here.
They have a separate panel. I am not going to interrupt them. I have been asked.
You want to file affidavit? No, madam, don't file affidavit. No, I will. That I will hear through the additional Solicitor General is here. I'll fix it up and hear him first on that point. He has a right of audience. So I will hear him on that point first. And thereafter I will go to you. No, no, I'm ascertaining from your opposition may not be necessary. Unless you insist. The additional Solicitor General does not insist for opposition.
No, but only thing that they, in view of the subsequent all events, continue.
Bring
after
in documents, I'll take on record. Admitted documents.
They should then produce the record.
Yes, you produce the records. I'll grant you liberty. Tell me a date, both of you. Sir, when you want it.
Any date, Your Lordship, I'm any date of your.
And come prepared on matters.
Yes, Your Lordship, I'm prepared, Your Lordship.
Yes, yes.
Lordship, only submission, Your Lordship, why I'm pressing for ad interim is.
No, ad interim order, I'm not inclined to grant. I'll clarify if you want. I'll fix it up in the month of July itself. Earlier. On the maybe I may not conclude this month. I have a little rush. I'll fix it at a 2 p.m. and take it up. এই কবে আছে বলো তো ওটা ওই মামলাটা কবে আছে আজকে কি বার বুধবার তো আজ বৃহস্পতিবার ও আজ তো নেওয়া হবে না ওয়েডনেসডে বলো তো 3rd জুলাই আছে কোনো মামলা ফিক্স করা
3rd July, Your Lordship.
Yes.
10th July.
10th July. Yes, some difficulties. 10th July. The writ petition shall be heard. Having heard the learned advocates appearing for the respective parties, I am of the view that the writ petition should be heard. Full stop. List this matter for further consideration. Heard though the point of maintainability as raised by the learned additional Solicitor General, it's kept open to be decided at the time of final hearing. Full stop. Since the writ petition since this matter may not require exchange of affidavits, I am of the view that the parties now, since this matter raises legal questions, the parties shall be at liberty to disclose to produce the records of the case. Full stop. In view, liberty I am granted. Expected they will bring it. In view thereof, let this matter be placed for final consideration under the same heading. Same heading is not important. So final consideration under the same heading on কবে বললাম
10 July.
10 July. 2 p.m.
2 p.m.
2 p.m.
2 p.m.
Yes, you will be here, sir.
Yes.
Certainly. So I'll get an opportunity to hear also to learn this.
But you also have vast experience at the bar and the bench.
Much obliged, Your Lordship.
Yes. And you kindly come with the statutory provisions handy with you so that it will be
Easier for me.
easier for you.
the
You have to have the entire statute to come to argue before a court.
Very well, Your Lordship. Because I was
And
at
was
my
this point considered by the Telangana High Court?
section 158, I'll satisfy that.
No,
is not applicable.
was it considered?
That section itself is not applicable.
Doesn't matter. Was it considered? No.
No, Your Lordship, this was not
I'll
a
do.
section,
Achha,
not
very-
a section which relates to cost recovery charges.
Very well. We'll consider this on that.
I'll satisfy Your
Very
Lordship, that
well.
section is not applicable.
Very well.
Item
Call the
number
next
5.
urgent matters. Oh, আরেকটা আছে আপগ্রেডিং ম্যাটার হবে না
Item number 5.
Yes. No, after the upgraded matters. After the upgraded matters. Because otherwise the upgraded matters will be. Yes, who is appearing? Item number 5. None appears in support of the petition. Though the matter had been upgraded at the instance of the petitioner. You are for the petitioner?
No, I can.
Stop. In view thereof, let the petition go out of the list. I have passed an order. Upgraded matters, if no one is there, then it is very difficult.
Item number 6.
Hello, time for the petition.
এখন দেবে না লিস্টে ওগুলো আপগ্রেডেড ম্যাটার বাইরে বেরিয়ে গেল
Affidavit of service.
গো আউট করে দিলাম ফিরে যাবে না গো আউট হ্যাঁ
My lord, do you have come against an order
rejecting my rectification application.
Yes.
My lord, what-
Rectification application, rejection. Main matter is not there.
Against the order in original or the adjudication order, we preferred a rectification application.
So you are not challenging the main order. You are only challenging the rectification order.
Rejection
Wonderful.
of the rectification order.
Wonderful. Yes, sir.
Well, it kindly comes to what happened, your lordship, in GSTR 1 and GSTR 3B. I have rightly stated the tax figure as 448,27,863 under CGST and under SGST each, your lordship. But while filing the annual return, I have added extra one digit, your lordship. The figure I have shown was 4 crore 82,78,634 under the CGST as well as under this.
Yes. Correctly done. Correct. Submission is correct.
Well, that is the submission. They did not appear.
Is it correct? Text
That
instruction.
is the only difficulty was, my lord, before the adjudicating order, they did not appear. They chose not to appear, not to reply. They chose not to reply. Now, after 1 year, if my lord sees after 1 year, they have filed this rectification application
no,
in
my-
2025.
No.
The order is of DRC 01, my lord, at the time of show cause also, that is of, my lord, if it is, my lord, I also feel if it is just a
Today, there is no tribunal available. Please understand. So therefore, either have to pay for an appeal. And the difficulty is, if the appellate authority mechanically dismisses the appeal once again, saying that it is delayed,
No, my lord, I'll come back.
one figure has been attached additionally in this. You have to consider this aspect.
My lord, we'll
Because
come back.
today, after all, you
If it is
cannot
a genuine
benefit
mistake,
at the absolute mistake. Which way, where?
Your lordship kindly comes to, your lordship, the
Although the writ petition has been filed challenging the
Your Lordship,
Louder, louder.
Your Lordship, I'm for the petitioner, Your Lordship. I'm led by Mr. Thakur, Your Lordship.
Continue, madam. You are with your file. Continue. Otherwise, I'll direct you to go out. Yes.
Your Lordship, a short pass over, Your Lordship.
Madam, continue. Otherwise, I'll direct you to go out.
Your Lordship, I'm the owner of a foreign vessel, Your Lordship. This rate is regarding I'm the owner of a foreign vessel, Your Lordship. I started discharging in port on 24th May, Your Lordship, wherein I had inadvertently discharged excess cargo on one receiver when it was supposed to be discharged on another receiver, Your Lordship. The receivers have agreed to get that excess cargo taken up from this receiver to another, Your Lordship.
You are a
I am the owner of the vessel, Your Lordship. I discharge excess cargo from to one receiver when it was supposed to be discharged to another receiver, Your Lordship. And the one who has received in excess is ready to get that cargo transferred to the one who has received in short, Your Lordship. So just formal orders are required for the customs to give directions and allow this.
Yes, madam. She claims that in ordinary process, while discharging a particular vessel of the oil, she had discharged additional oil to another particular vessel. That is your case? Now, this position is admitted between the parties, and the parties are ready and willing to set off this.
How can it be done?
Yes.
Take instruction or short instruction?
I'm so sorry, my lord, I was on.
No, your junior has placed it. Yes, wait.
No, I'll take short instruction on this.
Yes?
I'll take instruction on this, ma'am.
You take instructions.
Any day, my lord.
And this is it is an admitted position, Mr. Thakur.
Please, my lord.
This position is admitted. All the parties have agreed to.
Yes, my lord. All the parties have agreed. The person who has received excess, the person who has received short, even the customs, my lord.
Your Lordship, page 53, P9, Your Lordship.
50?
53, Your Lordship.
Yes.
Also, Your Lordship, both.
What is through lorry tanker means?
My lord, lorry tanker means, my lord, not through the pipeline. So from Imami's tank, my lord, a pipe will be fitted, which will discharge it into the lorry, the tanker, my lord. And your lordship sees page 55, my learned junior showed your lordship page 53. Can you see page 55? I'm sorry for this relay race, my lord. Now I'm here, my lord. Can you see page 55 once, please, my lord? Even the customs has signed this after the survey. Page 55, if your lordship has, kindly see at the bottom, Messrs. Purti Vanaspati is entitled to receive so-and-so quantity to be received from Imami Agrotech 117. And this is signed, my lord, by the customs also.
You are appearing for?
My lord, I am appearing for the vessel owner, my lord. What has happened is, unless this cargo is delivered to the vessel owner, the Purti will come and sue me for short delivery.
Then have you served both Purti?
Yes, my lord. I've served everybody. I've made them parties. I've served everybody, my lord.
Madam, have you checked up? Service is complete.
Yes, Your Lordship. Affidavit.
Have you checked up?
Yes, Your Lordship.
Who appears for these parts? These are private individuals, Mr.
Private entities, my lord, they are only interested in their goods. When they see that I'm seeking to give them delivery, I mean, in the customs also agrees, my lord, that 117 have to be given by Imami to Purti. Everybody, my lord, agrees to do.
If I pass an order and dispose it of in their absence, what will happen? Tomorrow someone else comes.
My lord, kindly keep it. Tomorrow I'll give notice to
affidavits, Mr. Thakur. You see,
there's no need. There's no need for it. My lord, may I do this? My lord, kindly keeps it tomorrow or any date convenient.
Monday, because
Monday, please. I will give them notice and come again, my lord, that this matter will be taken up on Monday. Only thing I request, my lord, your lordship kindly provides in the order that if they don't appear, final order will be made, my lord.
Now tell me this: why are you seeking for this order? That
No,
is
my
all.
lord, yes. Why I'm seeking for this order is, my lord, by my mistake on behalf of by my master of the vessel, my lord, pumped out excess quantity of cargo to Imami, which was Imami was not supposed to receive, Purti was supposed to receive. Now all of them agree that Purti is supposed to receive 170. Now, if this process is not carried out and the customs does not permit this process, I will be held liable by Purti for this short delivery of 117 metric tons. And customs may also come after me and say that you have given.
Where is this Purti Vanaspati?
Purti is also in Calcutta, my lord.
14.
Purti is at very close by Diamond Heritage, I think, my lord, on Strand Road.
14.
You are aware? Yes, Mr. No. Mr. Chakraborty? Yes.
My lord, Purti has also written to customs. Your lordship sees page 57.
Take it. I'll adjourn this matter till Monday. I'll direct them to serve, but you see, maybe they are not getting the intimation. That let them be here also, because I'll pass the order in their presence.
Yes,
there's no affidavits, but today if I pass an order and thereafter it transpires that ultimately they are not agreeable to this, then this will lead to
I follow, my lord. Your lordship is absolutely correct. I bow down to your lordship. Kindly only provide one line in the order, my lord, that if they,
I will.
in their absence on Monday, orders will be made, my lord.
Monday week, my lord, can it be?
No.
This is edible commodity.
They are online. So simple.
It's not about my inconvenience because there is no revenue loss in.
Ascertain and come back.
Not for that.
If you on Monday, if you come and say you have difficulty, I will accommodate you. You come back. The incident petition has been filed internally applying for a direction upon the respondent numbers 1 and 2 to permit the transfer of approximately 117.164 metric tons of crude palm oil from what is ST? Store tank?
Store tank, my lord. Store tank. Shore, my lord. Shore. SHORE. Shore.
Short tank, SHORE, short tank 10001. ST 10001 short tank of the respondent number 3 to the nominated short tank of the respondent number 4 at Holdia Dock Complex in the presence of the officers of the respondent numbers 1 and 2. Full stop. It is the petitioner's case that by reasons of a technical error, the petitioner had your vessel. You had.
Yes, my lord. I had discharged in excess quantity, my lord.
Had extracted.
My lord, discharged an excess quantity, my lord.
Discharged an excess quantity of crude palm oil of edible grade, which the respondent number 4 was entitled to. First of all. Though affidavit of service filed in court is taken on record. First of all.
Lordship, a supplementary affidavit.
For what? Supplementary affidavit for what?
For
My lord, Purti has also paid the customs duty on this cargo, my lord. Just to bring on record the customs duty paid by Purti.
Filed supplementary affidavit in court today, which is taken on record. Though by filing the affidavit of service, the petitioner would contend that service on the respondent numbers 3 and 4 is complete. However, having regard to the fact that the aforesaid order is likely to impact the respondent number 4, I am of the view that the petitioner should cause a fresh notice to be served on the office of the respondent number 4, indicating that the above writ petition shall be taken up for further consideration on Monday date diye dao. Mr. Chakraborty, shall I record? You are there? No.
My lord, just one line, please, my lord, if it commences to your lordship. That your lordship, if Purti does not appear on Monday, my lord, further orders may be passed, my lord. So that will be.
Not necessary. You come back, I'll pass. I'm directly.
No. Grateful, my lord. I'm sorry, my lord. I was.
That if you could ensure their presence.
Yes. Only to ensure their presence, my lord. Nothing else, my lord.
Find out who appears on their behalf.
I appear, my lord. Generally, I appear, but now there'll be somebody.
On their behalf. Then find out the solicitor who's there.
Yes, I'll find out. My lord. I know them, my lord. I'll ensure that they are there. Grateful, my lord. I'm sorry, my lord, I was not appearing in person today. My lord.
Yeah, was it? So it's all right.
Item number 8. Grateful.
As long as representation is there, there is no difficulty.
Grateful, my lord. Grateful.
Item number 8, here, Lordships, there are two issues. One is a negative blocking of my credit ledger without giving me a pre-decisional hearing.
Yes.
And now this one division bench of this Honorable High Court has held that negative blocking is allowed. Against that, the Supreme Court dismissed the SLP and left the question of law open because the matter was in the appeal stage. Negative blocking means the amount. Lordship, Basant Kumar Shaw. That against that SLP was dismissed with the question of law be kept open because alternate remedy was there. Now, Lordship, other high courts, Delhi High Court in batch of matter had considered this point, discussed the judgment of Calcutta High Court, distinguished it, and against that the SLP was preferred by the revenue. That revenue has been dismissed on merits. The SLP of the revenue has been dismissed on merits by the Honorable Supreme Court. Resulted. No, it was on the. It was stated that because there is questions of law were kept open.
Now, Madras High Court
Delhi High Court.
Consider this distinguished.
Revenue
Now, the Supreme Court again has not interfered.
Which is in favor. I'm not on that. But now because there is a because there was the leave was not granted, Lordship, on the motion day only it was dismissed, stating that there is no merits in the case, there is no interference under 136 is called for. First, Lordship, fine, I will distinguish whatever is the point, the new points which have come up after that judgment. The board has come up with certain clarifications. Today, Lordship, first, Lordship, this was, Lordship, they blocked my credit ledger on February 25. I replied to them and I asked them to adjudicate, at least do an adjudication. They write in the letter, their response, that we have time till 1 year, we will continue this. On record, they have written. Because 86 allows, I will show you, Lordship, what they have written. But, Lordship, this is one point. But why today I am before your Lordship more urgent is when they come for a search in my office. I explain, I'll just take 2 minutes. I have an office at Ho Chi Minh Sarani and my unit is in Jalan Industrial Complex. Now my accounts are maintained in Tally-based cloud server. So the two different teams of the same wing comes to my office as well as my factory. They do the inspection and at the factory, Bureau of Investigation, the Park Street Charge, my division office in State GST. My State GST proper officer came. One team came at my office, one team came at my factory, same day. Same. Now, the statements were recorded, Panchanama was recorded, it was stated that all the books of accounts of the assessee are based on cloud-based Tally server, which is accessible at the factory also because it is on cloud. And all the stock reports were shared from the head office to the factory, stock registers. Now, department claims that on the day of visit, as per section 35(1), 35(1) is the accounts and records section, Lordship. It says where you have to maintain your books of accounts. It says all principal place as well as additional place. It is written. And in electronic form. That is also written. So everywhere, Lordship, where there is SAP environment or Oracle environment or Tally environment, now because of the electronical advancement, everything is based on cloud. If I am sitting in America also, I can access my reach as extent, Lordship. So we gave all the stock registers and everything well on record. But the proper officer on the date of inspection seized my entire goods, which was lying at my factory stating these are unaccounted goods. All goods. And Lordship, I am a manufacturer of Bailey bridges, which I have to supply to Ministry of Defense, Indian Army. After this Operation Sindoor, I have all email communications wherein they are repeatedly asking us to give the orders early. Lordship, they have seized. Seized means I cannot use it. Order of seizure means order of prohibition, Lordship.
67.
Lordship, section 67. Yes. May I please, Lordships? Where the proper officer not below the rank of Joint Commissioner has reasons to believe that a taxable person has suppressed any transaction relating to supply of goods or service or both, or the stock of goods in hand, or has claimed ITC in excess of his entitlement under this Act, or has indulged in contravention of any of the provisions of this Act or rules to evade tax under this Act, or any person engaged in the transport, I am not covered by that, my limb is for, he may authorize, search, he may authorize, no, 67(2). Where the proper officer not been either pursuant to an inspection carried out under subsection 1 or otherwise has reasons to believe that goods liable to confiscation or any documents or books or things which in his opinion shall be useful or relevant to any proceeding under this Act are secreted in any place, he may authorize in writing any officer of central tax or state tax to search and seize, or he himself search and seize such goods. Lordships, the Panchrama. Lordship.
66.
Lordship, 60 onwards is the INS authorization. No, report. Their report. No, their report.
My report is at page 66.
Report.
My report is at page 66, where I have found discrepancies in his accounts.
Lordship.
That is the specific. Yes,
Lordship.
page 66. My lord, kindly come to specific finding starts from page 69 bottom. Specific finding. But what I have found.
Lordships, it has to be read. 2 paragraphs I will.
My lord, kindly see during inspection. My lord, kindly just may I place it to 69 bottom. During verification of the submitted books of accounts, discrepancies found between purchase ledger and purchase challans filed mentioned so and so. Thereafter I have given him an opportunity. Taxpayer is allowed. Next para, kindly see. Enough of you produce plausible explanation along with supporting documents to reconcile the aforesaid anomalies. From after allowing the same, RP could not produce any relevant documents to represent the case accordingly. Thereafter, my lord, I have exercised my powers. Subsequently, on receipt of the other. My lord, reason to. No, my lord, kindly see. My lord, with deepest respect, kindly then allow me to place it accordingly. Yeah, okay. But first is reason to believe. Reason to believe is in the at the inception. Kindly see the 67(1 then. No, reason to believe is 67(1, where the proper officer, not the coming one by one. My lord, kindly. I know. At the time, authorized officer, when the not either pursuant to an inspection. 67(2, my lord, kindly. Allow me to 1 minute to just read out the provision. Where the proper officer, not below the rank of the Joint Commissioner, either pursuant to an inspection carried out under subsection 1 or otherwise has reason to believe that any goods liable to confiscation or any documents. This is what is my lord is saying. Now kindly see what I have seen. Kindly come to 69 first. After communication with the second team, 2 teams had visited 2 different offices. 69. Principal place of business, the following books of account is mailed to the authorized representatives at the additional place of business, Mr. Abhishek, which is a so and so. These are the documents I found. Purchase register, all these were considered. So this was a considered. Now I say, during verification of the submitted books of accounts, discrepancies found between the purchase ledger and purchase challan file mentioned maintained at so and so. Section 35(1) of the mandates every registered person to maintain separate books of account for both principal place of business and additional place of business. On this date, during inspection, no separate production and consumption register is maintained. physical stock of all raw materials, semi-finished and finished goods are identified and wanted and counted by the authorized representative in our subsequently these goods are enlisted in details in a separate checklist named so and so. The taxpayer is allowed enough opportunity to produce plausible explanation along with supporting documents to reconcile the aforesaid anomalies. From after allowing the same, the RP could not produce any relevant document to represent the case accordingly. Aforesaid facts and anomalies were communicated through email to the learned senior joint commissioner of revenue so and so. On being satisfied, the proper authorized and required the undersigned to search the above premises and seize the goods for documents relevant to the instant case proceedings under the provisions of subsequent receipt of the authorization. The undersigned proceeds to take necessary action in accordance with 67(2). Anomalies I found,
Satisfaction for Caesar is one. For satisfaction for search is one. Satisfaction for Caesar. Their only way to
well, not only goods liable on but I have found the documents. There are discrepancies in the documents in his stock register. Well, stock register, well, subject kindly see to confiscation or any document or books which in his official useful or relevant to any proceedings. Well, I am not for proceedings. I require these documents. Section 72. But kindly just yes. Where the proper officer, not below the rank of joint commissioner, either pursuant to an inspection carried out under subsection or otherwise, has reason to believe the goods liable to confiscation or any document or books or things which in his opinion shall be useful for and or relevant to any proceedings under this act are secreted in any place, he may authorize in writing any other officer of central staff to search and seize or may himself search and seize such goods or documents. But once I found documents which does not match with his stocks or the books, it is to be considered as a secreted and I require this for the purpose of my proceeding. 74(1) I have issued now.
No, my lordship, that is my case. Exactly what my learned friend has stated.
My lord, the test stage. But he wanted to secure.
Lordship, they have issued.
Secure
20%, lordship. I want to use my goods. 141 will not apply.
satisfaction. Satisfaction. The order cannot be. And you cannot improve this also.
Well, I cannot improve by on writing, but lordships, the test, if lordships holds the test for a judicial officer.
I will allow you to pick it up.
Lordship, Bailey Bridges for Ministry of Defense. And I have attached those orders, work orders, which they are asking us to give. Lordship, what I am saying, Lordship, this issue, they have issued now a show cause. Why I came before your Lordships? Under section 35(1) read with 122. They are imposing me on penalty of 70 lakhs. And how they value it? They took my stock register, which they, at the first stage, what your Lordship said, they did not rely. Subsequently, they realize. And they do a valuation as per my calculation and add 15% markup. They write in the show cause. No. Lordship, Caesar, from Caesar it happens. Caesar and the blocking. So, Lordship, today, no, Lordship, today, Lordship, I am ready. 20%, if after all I go to appeal, 70 lakhs penalty. They have not, what my learned friend submitted, 74 proceeding. I also say this should be a case of 74 proceeding. Lordship, they have issued a proceeding of 35(1) read with 122, which the Honorable Supreme Court, the matter traveled. Lordships, let me explain, Lordship. No, no, Lordships, kindly appreciates what they have asked today. No, no, Lordship, today what they have, at what stage today they have asked? Kindly give me 2 minutes to explain, Lordships. Today, after all the reconciliations we were submitting, we are going, when they have not agreed anything, now they somehow come up to a calculation. They say, these goods are liable for confiscation. The penalty you have to pay 70 lakhs. They have computed as per their calculations. Now today, Lordships, these same issues, what they did. Yes, Lordship. So whatever was my stock register produced on the day of inspection, on which is recorded that it was emailed from the head office to the team sitting at the factory. So they now consider that. And Lordship kindly appreciates manual checking, manual counting of all those. I am still not going. Lordship, I am ready. 20% of penalty they have determined. I am ready to, because Lordship, value of the goods they have determined as after adding 15% of the penalty, Lordships. No, Lordship, value of the goods after adding 15% as our profit margin, they have determined the value of the goods to be 3 crore 89 lakhs. And the penalty they have imposed on me is 70 lakhs. Lordship, they have not, that is what the entire proceeding is bad. Supreme Court has held, the matter traveled from the Allahabad High Court, that whenever there is a case of excess stock or less stock, a proceeding under 73 or 74 is mandated. Kindly takes 35(6) once. Kindly takes 35(6). My challenge will sustain, Lordship, but I today want the goods, therefore I am before your Lordship. Page 35, section 35(6). Subject to the provisions of clause H of sections 5 of 17, where registered person fails to account for 35(6). CGST or the WBGST accounts and records. Section 35, 35 subsection 6. 35, Lordship. Lordship, 35 is accounts and records. Now, Lordship, 35(6) I am directly placing. Subject to the provisions of clause H of 5 of 17, where the registered person fails to account for goods or services or both in accordance with subsection 1, the proper officer shall determine the amount of tax payable on the goods or services or both that are not accounted for, as if such goods or services or both had been supplied by such person, and provisions of 73, 74, 74 as maybe will be applicable.
Same as section 65(6).
Exactly. Exactly. Now what my officer does, he issues me a show cause under 35(6), but under 120 to 118. Lordship, that is at page number 196. He only imposes me, he calculates some penalty. And in the show cause, he says that these goods are liable for confiscation under 130. Therefore, 130, I will read with 120 to 118 and I will impose penalty on you. Direct DRC 1. The detailed show cause starts at page 198. Lordship, show cause issued under 120 to 1, the heading. Wherein 35(6) is very clear. You have to go under a proceeding of 73, 74 or 74. No, no, Lordship. 73, 122, 1 is a separate. Kindly takes up what is 122. It is penalty heading, penalty for certain offences. 122 is a separate chapter for levy of penalty. Today, but 35(6) mandates him to issue a show cause notice under 73, 74, which can go into adjudication. So I will challenge these all in the subsequent manual. I have challenged this also. I stated, Lordship, from initiation I have challenged. Now, Lordship, today, because my government orders 20% of the 20% of the penalty.
But 20%
I will pay. I have
20%
of the penalty what they have imposed. I will
20%
secure.
he is agreeing.
Because
improve on it.
That's fine, because I have instructions from the client today because of the Ministry of Defense pressuring us that I have to give this delivery within 30th June.
My lord is putting with deepest respect, putting the test as if they are judicial officers, my lord. My lord, there is a discrepancy. No, my lord.
You will see someone's property,
my lord,
take it out from his godown, and you will not discharge your statutory burden of recording your satisfaction.
What
is this rank? Is he at large?
My lord, may I try to answer? May I try to answer? But satisfaction to what? It is a subjective satisfaction. I have found that there are discrepancies. Is it not a satisfaction? Is it not, if I have found the stock is not as per his accounts?
Search and seizure, penalty, enforced, order executed, transfer at midnight.
There are extreme, extremes are there, my lord. Extremes are there. No. It's for state, it is not an extreme, my lord. I can.
What is this turnover?
Turnover, lordships, I will have to ask, but still it will be some in crores.
That, or else, my lord, they cannot afford him. There has to be turnover, has to be, or else they cannot afford him.
Lordship, and my blocking,
lordship,
lordship, one more point, lordship, that negative blocking, Honorable Supreme Court, the matter, another matter, that a pre-decisional hearing.
How many
Lordship,
issues will be?
Lordship, lordship,
how many?
no, lordship,
how
lordship,
many
one point.
issues can be raised in one writ petition? My lord, whatever we have learned.
Lordship, he has written.
No, whatever. My lord, I'll satisfy, my lord, the nomenclature of a show.
Lordship, lordship, just something
that.
for blocking, lordship. Let them adjudicate me for blocking, lordship. They have written that.
all issues.
अरे एक रेट पे 4 इशू तो एक
हाँ बोल ना
convinced with that.
Lordship, I'll place. Yes, Lordship, I will try to assess you. Get.
Other matters are released.
Yes, item number 9. Item number 9.
The most, the most painful part of the provision. The most painful part. I wish your lordship had not fixed it at 2 o'clock. I can't, because I can't say no. If that's a difficult part.
With this matter, has a checkered history, and what we have done for the lordship's kind consideration and convenience, we have prepared a list of dates. And I will go by the list of dates and take your lordship from 1980. Kindly, this is an updated one. This is an updated one. This is an updated one. May I take your lordship, I am not. One 1459 of 1957, Kirorimal Bhivaniwala, also known as Kirorimal Lohriwala versus Premchand Gupta. Well, at that point of time, the petitioner was a minor. This Honorable Court appointed official receiver as the receiver of joint movable and immovable properties of the parties to the suit, including premises number 43 Prithviraj Road, New Delhi. December 1960. Well, I will take your lordship directly to that document, which is page 32 of additional volume. Well, if your lordship kindly gives the additional volume. Very well, madam. Then I will take your lordship to the relevant documents. That is one way we can do. So, madam, that is there. So, December 1960, official receiver was discharged and the plaintiff was appointed as the receiver of the Delhi property. At a list of dates, the revenue these dates should have been posted just before December 19, 1960, May 21, 1957. But this is the triggering point of the entire issue. Since allegedly a sum of rupees 27,18,562 on account of areas of income tax was not paid, certificate proceedings were initiated in Delhi. Now, August 24, 1959, the Income Tax Department made an application, but this is extremely relevant, made an application to this Honorable Court in the said suit, praying inter alia for leave to attach the properties of the said parties now in the hands of the receiver and to sell. My lord will kindly, if your lordship so pleases, kindly take note of the premises number. Sell the premises number 181 CR Avenue, Calcutta, and 8 Narayan Prasad Babu Lane, Calcutta, through Certificate Officer Alipur 24 Parganas and released through him and realized through him the said income tax dues. Now, August 2, 1960, the leave to attach properties in the hands of the receiver sought for by the Income Tax Department was granted by this court. Leave was also granted to proceed under section 46(5)(a) of the Income Tax Act 1922. Well, at that point of time, that was the relevant provision for attachment and sale of properties. Well, the areas of areas are to be realized through sale of properties. Those were the relevant provisions. I will take your lordship to that, but not at this stage. My lord, now 4161. But this is this is a different proceeding, but we have included in the list of dates. The plaintiff filed eviction proceeding under Section 14 of Delhi Rent Control Act before Rent Controller Delhi against V.N. Vasudeva. My lord, Mr. Mitra is appearing and representing Vasudeva, being case number 67 of 1961, praying for recovery of area rents and his personal requirement of the Delhi property. August 18, 1964, my lord, Income Tax Department sold the Delhi property to V.N. Vasudeva for a sum of rupees 2,60,000. But সেটা তো পরে মানে only one thing, may I just know, take your lordship through. This Delhi property is 43 Prithviraj Road. Lordship will, if your lordship goes back to the list of dates being August 24, 1959, your lordship will find leave was sought for from this honorable court in the pending suit at that relevant point of time for sale of premises number 181A CR Avenue and 8 Narayan Prasad Babu Lane, Calcutta, through certificate officer. So, my lord, so far as the application which was made on August 24, 1959, I'm sorry, my lord, no leave was sought for sale of Delhi property being 43 Prithviraj Road. Now, my lord, this suit which was filed, eviction suit, my lord, I take your lordship once again back to 4/1/1961. This suit was dismissed for default on 9/3/65. That is, that was not so relevant, but in any event, now my lord, kindly take August 18, 1964. It was sold to Vasudeva. Yes. Receiver, not liquidator. My lord, official receiver was appointed with respect to all the property. Yes. But the income, did he take possession of the property, official receiver? No, possession of the property was not taken. But my lord, no, at no point of time, subject to correction, no possession was taken by the official receiver. Not even symbolic. Symbolic possession was taken. My lord, I will not make this statement today. My lord, I have to take, I will not make statement without looking into the record. It's not appropriate. Yes. My lord, perhaps, my lord, no possession, no physical possession was taken. That's all I can say. Two Calcutta properties. Calcutta properties. Now, my lord, now kindly take, my lord, now August 18, 1964, Income Tax Department sold the Delhi property to Vasudeva for a sum of rupees 2,60,000. February 12, 1965, the plaintiff registered objections against the sale so made by the Income Tax Department. However, the Chief Commissioner rejected the said objections and confirmed the purported sale. So the sale was confirmed. Well, now we come to the core issue. March 15, 1965. Matters got that? Income Tax Department realized that the order dated 2/8/1960 may not be considered sufficient leave, that is missing, sufficient leave for sale of Delhi property, and hence it took out an application praying for following relief. But I will place those documents. Today I'm just reading out the list of dates and give your lordship an overview of the matter. Omission to obtain leave from this honorable court before putting up the Delhi property for sale be condoned and leave be given to complete the said sale in favor of the said V.N. Vasudeva and to take further steps for giving effect thereto. Now, kindly take the next date. This is, my lord, September 8, 1965. Upon hearing the parties, this honorable court passed the following order. This is extremely relevant because it, ultimately, perhaps, it will all boil down to this order. The entire core issue revolves around the interpretation of this order. It is ordered that the said applicant union be at liberty to put up the Delhi property being joint, movable and immovable properties, including premises number 43 Prithviraj Road. Well, that's a typo. It's not 4353 not. It's 43 Prithviraj Road, New Delhi, for sale either by public auction or by private treaty to the best purchaser for purchasers that can be got for the same. So, Malad, this is the leave granted for sale. Malad, we will come to the application which was made by the Income Tax Department. I will take your lordship to the entirety of the order. And so this leave was granted. 22nd or 25th September 1976. Malad, we cross one decade rather. And we come to 76. Malad, this is Sundar Gupta, right? SCG Sundar, PCG. I think that's a typo again. Premchand Gupta. I'm sorry. Premchand Gupta submitted a proposal for settlement of dues and made it clear that he is the absolute owner of the Delhi property. October 13, 1976, CIT West Bengal 6 acknowledged the receipt of the letter dated 22nd or 25th September 1976. 13 or 14 January 1977, CIT West Bengal 6 through ITO headquarters advised Premchand Gupta to send the petition to CBDT Delhi with a request for early decision on his petition for settlement of income tax dues. September 24, 1979, ITO Ward A, that is Kolkata, sent a notice to Premchand Gupta requesting him to file details of proceedings in relation to the Delhi property for the purpose of scaling down or partial write-off of the tax areas. 15th or 16th May 1983, the petitioner submitted proposal to Chairman CBDT for settlement of dues. July 21, 1983, CBDT expressed its inability to interfere in the matter. However, the petition was forwarded to CIT West Bengal 6. August 11, 1983, the Income Tax Department declined to scale down the demand to rupees 20 lakhs. However, kept the window open for fresh proposal. December 1985, and this is when the petition, this present petition was filed. The petitioner filed the present writ petition praying inter alia for a declaration that the purported sale dated August 18, 1964 and the issuance of the certificate of confirmation of sale dated April 1, 1965 in respect of the Delhi property are null and void and of no effect whatsoever. The petitioner, but this was a suit which the petitioner filed in Delhi. Now, October 3, 1985, this suit was dismissed. We have also included in our list of dates. October 26, 1990, the Honorable Court dismissed the present writ petition, passed on the ground that the petitioner already resorted to alternative remedy and the suit is pending. That was an incorrect recording of fact because by that time, the suit was dismissed for default. The suit was dismissed for default on October 3, 1986. The hearing of the writ petition was concluded prior to dismissal of suit on October 3, 1986. However, the judgment was delivered 4 years later on October 26, 1990, and hence the pendency has been erroneously recorded in the said judgment, and the writ petition was dismissed on the ground that the petitioner has resorted to civil remedies. February 1994. But this is the sister of the petitioner who filed the writ petition challenging the sale of property, Delhi property by income tax authorities. They said, firstly, initially the writ petition was allowed by an order dated 8/11/1995, but subsequently this writ petition was, the order was recalled. But it was made clear that this will not affect the proceedings initiated by her brother, namely Sundar Lal Gupta. Your Lordship will find that. I will place that order. Now, now, November 20, 1998, this is when, the review application taken out by the petitioner against the order dated October 26, 1990 was allowed by this Honorable Court. August 17, 2001, Vasudeva carried the judgment dated November 29. writ petition was dismissed and recognized. So, my lord, writ petition has to be heard. The Vasudeva carried this judgment dated November 20, 1998 to the division bench by way of an intra-court appeal. The division bench disposed of the appeal with certain observations. It was also observed that the order dated October 26, 1990, dismissing the writ petition should not be recalled. But this was the division bench observation. But the appeal was not allowed, appeal was disposed of. I will place the orders. May I take your lordship to then 2? Appeal from the review. Appeal from the review. Recall the order. The recalling order was carried to division bench by Vasudeva. It was not, it was then what happened? Subsequently, the Vasudeva's preferred SLP against this order. The Vasudeva's preferred SLP in this order against this order. I mean the respondents before lordship. And in the said SLP, Vasudevas accepted the order dated November 20, 1998 was upheld by the distribution bench. But this was the ground which was taken. Then, my lord, rendered positive findings. It is order dated 27, which was sought to be reviewed. The learned single judge rendered positive, which are incorporated herein below for the sake of convenience of the honorable court. I will take your lordship to these observations later, or you want lordship wants me to go through the orders one by one. If your lordship wants me to go through the orders one by one, I will take your lordship from 19. The SLP was dismissed. Then, my lord, on March 31, 2006, the writ petition came up for hearing before this honorable court. When upon hearing the parties, the honorable single judge observed that in view of the judgment and order dated August 17, 2001 to pass by honorable division bench, nothing was pending before the court. So, my lord, the order should not be recalled. That observation played a key factor when, my lord, the writ petition again came up for hearing, except the miscellaneous application taken out by the contesting respondents. Now, my lord, now the petitioner carried this judgment dated March 31, 2006 by way of an intra-court appeal before the honorable division bench. Murders got that date after March 31, 2006. October. No, man, I will go through your lordship. May I take your lordship to March 31, 2006 order? Later. Then October 19, 2012, the petitioner carried the appeal, preferred an appeal being mat number so and so against the order dated March 31, 2006. Upon hearing the parties, the division bench granted leave to the petitioner to file suit in accordance with law in the appropriate court on the self-same cause of action and the facts mentioned in the writ petition. The Union of India filed certain written notes, which I will come to later. Then, my lord, we took out a review application against the order passed by the division bench, which your lordship will find the date, that is September 24, 2014. The petitioner made an application being so and so for reviewing the judgment on order dated October 19, 2012, passed in FMA number so and so. The division bench held that the order dated March 31, 2006 was erroneous when the honorable single judge proceeded to hold that the division bench in MAT had set aside the order dated November 28, 1998 and restored that of the order of October 26, 1990. Division bench allowed the application for review and recalled the order dated October 19, 2012 and was pleased to set aside the judgment and order dated March 31, 2006, passed in the present writ petition. Now it has got that. Orders I will place it. March 31, 2006 is the dismissal of writ petition. May I just give your lordship the brief fact, just for your lordship's kind consideration. My lord, the writ petition was dismissed in 1990, right? Then, my lord, when the writ petition was dismissed in 1990, my lord, thereafter, if your lordship comes back to the list of dates, lordship will find no, my lord, may I just give you a lot? Right, this is the division bench order. Right. Your lordship is reading which order, my lord? Subject to 31st March 2006 order. My lord, that dismissed, then that order was carried to the honorable division bench. That or the honorable division bench was pleased to confirm the first confirm the order. Then, my lord, a review application was taken out against the order passed by the honorable division bench. In the review application, this March 31, 2006 order was set aside and the order passed. Writ petition revise. Writ petition revise. Then, my lord, may I take your lordship to? Well, I was at 2024 review. Well, I can't. 2014. Then, my lord, kindly take July to 2019. My lord, the Vasudevas carried this judgment. And the judgment allowing the review. The division bench judgment allowing the review petition filed by the petitioners. Carried this judgment on order dated September 24, 2014 to the Honorable Supreme Court in CA number so and so. The Honorable Supreme Court held that no error had been committed by the High Court, passing the judgment and order dated September 24, 2014 in excess of its jurisdiction and dismissed the appeal. So, my lord, so the revival is sustained by the Honorable Supreme Court. Now, there are observations, there are certain grounds which were taken out in the SLP filed by Vasudevas, which I will place later on. This is part of the list of dates, but I will place that later on. But this is the time travel, my lord. It starts from 1958. God knows when will it end. I am seeking in the writ petition, my lord, the declaration, your lordship will find my prayers, that the sale which was effected, sale of daily property which was effected without the leave of the court, that sale should be declared null and void. Malad, the sale had been, if the sale is declared null and void, then we have to examine, first the sale has to be declared null and void. Sale was not made by the receiver, sale was made by the income tax department. For first, right. No, our understanding, and it's a clear, no, kindly take, my lord, what leave was granted. The leave which was granted, kindly come back to 1965. This is, my lord, 8 September 1965. Well, first I have to read the application which was filed before the income tax department by the income tax department. It is ordered. What was prayed for? Omission to obtain leave from this honorable court before putting up the daily property for sale be condoned and leave be given to complete the said sale in favor. Yes. So, have also participated in I do not know. It is ordered. The application was taken out by income tax department. The application, I was a party to that. Absolutely, my lord. But what was drawn up is that it is ordered that the said applicant union be at liberty to put up the daily. It's not that regularizing the earlier sale. It's a leave granted to the income tax department to put it up for auction, public auction. And then, my lord, there is no prayer for condonation was not allowed. It was a there was a specific prayer.
Aspects are different. Certainly, because like a 12-way leave cannot be same as a leave under section 446 of the Companies Act.
Right.
Now, there if a leave is granted,
But your lordship will kindly
whether a post-facto leave can be granted, regularize the suit. Right.
My question is that what is the language of the leave granted by the honorable court? But we have to go by the language of the leave granted by the honorable court. But my lord, there are several, my lord, the orders passed. Yes. 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 Certainly. Certainly. My lord.
No. Your lordship need not be sorry. What I done? But I tell you, lordship. I tell you, lordship, the problem. Problem is, my lord, one court is court room number 11. Another court is court number 5. The other court is, my lord, 37. The fourth court is, my lord, 274.
My lord, next week, my lord, not on Thursday. Not on Thursday, my lord. Thursday, there is already a fixed matter. But next Thursday and Thursday week, my lord, I am held up. But both
Then
on
keep
20.
it in the month of July. Yes, quite right. My lord, your lordship remembers
Not the entirety facts. There are several orders passed thereafter. Yes. I will place the orders and the pleadings. And the pleadings which have been exchanged by the parties. Yes. Well, kindly keep it on 11th then. Friday. No. Friday, my lord, then 12th.
11, 12, কোথায় feel 11,
July.
11th হচ্ছে Friday.
Sorry, 11th is Friday.
12th is Saturday.
Well, don't keep it on Friday, my lord, subject to your lordship's kind consideration. 2nd. Next week. Well, when, my lord? Next week, Friday, 27.
27 only wanted on the next step, but not your. Then we your effort that we have to be.
No. Well, then we come back on 27th and Friday. 27th is okay. 4th July, I am not in Calcutta, not here, man. 27th, I have no difficulty, my lord. That is why, my lord, 10th July, 11th July, whichever day. Then 11th July.
11th July. I don't have any problem. Your lordship looks into your diary.
11th July, your lordships may be leaving for Jalpaiguri. 12th is the inauguration day, I think.
12th July is a Saturday.
Inauguration day, sir. No, I have no problem. Both I am not here, man. I am not in Calcutta.
4th, my learned friend is not in Calcutta. That is the best day. Well, ওই দিনই best.
July. ওর আবার অসুবিধা হবে। 11th then, man. 11th from 2 p.m. In any event, manner, we will get it till 3:30. That's a Friday.
And usually for this court, that are also.
My lord, that will not be after 3:30, my lord. 2 to 3, we'll come.
Yes, sir.
11 তারিখ। Interesting.
I am for the income.
Well, not my money, yes. Well, if I succeed, if I succeed, he refunds the money to Mr. Mitro's client. If I fail, well, Mr. Mitro's client gets the property. That's the whole issue.
Income tax department will be breathing down your
But
neck,
Malad,
my neck,
when your
everybody's neck.
lordship will be considering the leave, the lordship will kindly consider the provisions of 46 of the Income Tax Act as it then stood. But not a general leave. Second shift. Yes. But 46. I'll take your lordship through that. Take your lordship. But my, I have to place all the orders. No. This is the first matter. This is the first matter. Your lordship will be considering the provisions of 22 Act. The 22 Act, my lord. Go back to 22. Yes.
Don't go conclude. At a minute, chalak. I'm 420. Don't conclude at 420.
Okay.
Item number 10 and 11, I am praying for not today. Unfortunately. No, sir, actually, the senior, he could not reach.
Item number 11.
10 and 11, same.
12. Item number 12.
List 11.
টেন ইলেভেন
10.
আপনার
হ্যাঁ
এটা কবে হবে বলছে সোমবার বুধবার বললেন